Morning. So you can see, obviously, the committee is, it's Monday. They're going to be a little late. Probably waiting on Liberals. Conservatives are probably in the House. So what I'd like to do is show a couple clips that they did really well on my TikTok, but they didn't do too well on YouTube, which is interesting because I find these clips hilarious. This is MP Lewis. She's one of my favorite Conservative MPs. Kind of underrated. She's a little bit of a backbench, but she's a doctor, and she's hilarious in this clip.
The Prime Minister has put on blackface so many times. He has degraded black people. He literally put a banana in his pants, and you have the audacity to stand and look at me as a black woman and ask about my meeting with another member of the European Parliament. That is within my job description. I do not have to approve of everything that another member believes in order to have the decency to have meetings with other individuals. Your Prime Minister, this Prime Minister, denigrated black men by putting a banana in his pants. Shame on every member over there that does not chastise them. If this were any other country, he would not be leading, and he would not have the moral authority to lead. He would not have that moral authority.
So true.
Okay, so that's one of her clips. I know you guys usually don't see her, which is why I wanted to showcase her a little bit while we're waiting for committee, because she is great. Here's her in committee.
Once again, you have 5 minutes, please.
Yes, so Minister, I want to ask you something specific that falls under your portfolio. As the Minister responsible for housing and who is accountable to the National Housing Agency, is the CEO of CMHC receiving a bonus this year?
I don't typically involve myself with the compensation of employees of Crown Corps. I don't know what the status of bonus. I would point out there's an interim CEO right now, and it may be a unique structure.
Do you not see the budget GIC process for the CEO?
It hasn't been determined yet. Sorry, I could just as easily yield, although my deputies just shared with me that it's a governor and council process and that the bonus hasn't actually been determined.
Been determined, okay. And do you think that it's fair that the CEO of CMHC receives a bonus in a year where housing starts are down?
I think it's important that elected officials don't try to interfere with the compensation scheme set for public servants. I think it would be a bad practice. So from my perspective, if there is a process that people were following, that process ought to be followed.
So performance could be dismal, and your government would still would still think it's okay for public servants or CEOs of crown corporations or agencies to receive bonuses, even though performance is abysmal?
Well, the performance standards reflected in a given bonus structure should reward performance. Now, there's housing conditions that are challenging that may be inside or outside of a person's control. But again, once you have a process designed to reward performance, that process should be abided by.
And when performance is down, there should be bonuses. Is that what you're saying?
Yeah, those are your words, not mine.
Okay. Well, can we go back to one of your previous answers, ministers? You stated that the $4 billion Housing Accelerator Fund that I referred to was incorrect, but that's actually on page 45 of the budget. Are you going to correct that response,
You had
Minister?
said $4.4 billion. $4 billion was administered previously. Not all of that money has actually been spent because most cases involve a municipality that only gets a 25% upfront payment, so we can protect against the risk that a community wouldn't follow through on the performance that they've agreed to in the particular agreement. So,
how many houses has been built as a result of that $4 billion that you reference?
Well, the specific funding leads to systemic changes that will have an impact over time. The communities that we've partnered with have indicated that over the next decade, they expect an increase in building permits issued of 750,000 across Canada.
And so we've seen property taxes, we've seen costs increase for homeowners in places like Toronto, while the federal government is dishing out $4 billion in a housing accelerator fund. Will you commit today in not giving out any housing accelerator money to cities that increase development charges or other taxes on home buyers?
When we deal with the development cost charges, we use the Canada Housing Infrastructure Fund that was in the recent federal budget, not the Housing Accelerator Fund.
Minister.
That we're only funding infrastructure differently, but the Housing Accelerator Fund agreement was designed not around development cost charges,
So there's
around
no commitment
permits
today.
and
I'm going to
zoning
move on
practices.
with my question. Your government has set some pretty ambitious targets to build homes in for Canadians. Your government's goal is 3.9 million homes in 2031. That's 1.096 homes must be built every minute. That's 65 homes per hour. We've been here just over 30 minutes. Has your government built 32 homes in the last 32 minutes, Minister?
My view is that people who would suggest a problem is impossible to solve shouldn't try to interfere with the person who's trying to actually solve it. If your goal is to throw up obstacles every way, feel free, have a field day. I want to solve the housing crisis. My goal is actually based around what I think it will take
the worst housing in
as I expect.
Okay. Committee starting.
I call this meeting to order. Welcome to this meeting of the Standing Committee on Public Accounting.
Orders. Members are attending in person in the room and remotely using the Zoom application. Before we begin, I'd like to ask all in-person participants to read the guidelines written on the updated cards on the table. These measures are in place to help prevent audio and feedback incidents and to protect the health and safety of all participants, including and especially the interpreters. You'll also notice a QR code on the card which links to a short awareness video. I am told that there is some audio issue. It's mild at this point. It's affecting all of our witnesses and 2 members who are joining us remotely. So I'm going to ask that when you are making your opening statements with respect to the witnesses, to speak slowly and clearly. And this goes, of course, for members as well. When you're questioning witnesses, to speak slowly and clearly. There's no issue that's causing any disruption now, but if it intensifies, then we might have to pause the committee hearing. A reminder that all comments should be addressed to the chair. Conformément à l'article 108.3G du règlement, le comité reprend l'examen du rapport 6. Technologie du...
Pursuant to the standing order, the committee is resuming its study of reports 5-7 of the Auditor General sent to committee on June 4th, 2024.
To note some committee membership changes. We have joining us Mr. Drouin. Welcome. Good to see you. And nice for you to join the committee.
Merci.
As well, who's a permanent member, but joining us online is Mr. Erskine Smith. Welcome to the committee.
Thanks very much.
Appreciate having us. And of course, another member who's not with us today, but is old hat, is Kelly McCauley on the opposition side, who is back with us once again. And of course, I'd be remiss, Mr. Long, it's always good to see a fellow New Brunswicker on the committee.
You too, Chair.
Good to see you here today, so thanks for joining us. Right, just going to now welcome our witnesses, and we'll begin to get going here. Joining us by video conference as individuals, Stephen Kukucha. Nice to see you. Thank you for joining us. And as well, Guy Ouimet, Corporate Director, also joining us as a witness by video conference. You each have 5 minutes for opening remarks. I tend to just go by the order here, which would begin with Mr. Kukucha, but if you 2 gentlemen had prearranged things, you're welcome to say so. Otherwise, Mr. Kukucha, you have the floor for 5 minutes, please.
Thank you, Mr. Chair and honorable members. I am Stephen Kukucha, and I served on the SDTC board from February 2021 to May 2024. I live in Vancouver. I'm a retired lawyer. I'm certified by the Institute of Corporate Directors. These opening remarks will largely mirror the opening remarks I made to committee in 2023. To start, I believed in SDTC's work and that it was critical to the development and success of Canada's clean tech ecosystem. And while I acknowledge both the OAG and McCarthy reports and the shortcomings laid out, I feel compelled to state that there was a lot of good work done and critical funding support for deserving companies. I joined the board because I believe my unique perspective and positions within the clean tech sector could add value. My almost 25 years of experience in clean tech gave me an understanding of the challenges companies face in acquiring capital. That struggle was obviously exacerbated by the market downturn in late 2021, the dramatic increase in U.S. government investment in the space, and then the pause of SDTC's work. It's good to see the government will continue funding via the NRC. As well as my work in clean tech, I should also disclose up front that I have been involved in politics in the past, both federally and in British Columbia, and I'm proud of that involvement. I believe engagement in our country's democratic process, no matter what party one supports, is important to civil society. For example, I have a profound respect for your decisions to run for office and to seek careers in public service. It is one of the more important things a Canadian can do. Most importantly, I also need to disclose that I was the recipient of the whistleblower call to the board on January 27th, 2023. That call and my subsequent actions led to the board initiating a special committee, which I participated in, and then an investigation. Unknown to me, the whistleblower call was surreptitiously recorded. However, I will reiterate that I'm comfortable tabling a transcript of that call to show the level of professionalism this individual was afforded in good faith. Alternatively, you can ask the whistleblower to share the tape, as I understand they have testified. It's also very important to make clear on multiple occasions the whistleblower was asked to share their dossier and all the facts they were basing their allegations upon so that the board could respond and address them in a professional manner. Unfortunately, they did not share the dossier, and the board was left to investigate without a full suite of information possible. During my 1-hour conversation with this individual, whom I believe was not the same person that testified at this committee, I took contemporaneous notes. After the call, I immediately realized the board needed to be informed and legal counsel engaged with a proper process followed. Even the Auditor General acknowledged the whistleblower was handled appropriately. An immediate investigation was commenced without informing the individuals that were subject of the allegations. I acted in good faith, followed proper governance, and in my opinion, undertook my duty. The board and I took this extremely seriously. SDTC was created by an act of parliament and was funded by government. It was a Canadian institution with a critical mandate. Because of that, it was important to investigate fully with the information we have and take whatever actions necessary. Our national institutions are important and worth protecting. Regarding my minor investments in clean tech companies, any and all conflicts were disclosed prior to my appointment, and all my investments were made years prior to my appointment as well. Further, based on my review of the facts, the vast majority of the funds that any of these companies received were provided to them prior to, well before I was appointed, with the exception of the COVID payments, which I will address momentarily. In fact, prior to joining the board, I was asked to resign from the board of a company that had previously received SDTC funds, and I promptly did so. And any conflicts after joining, either real or perceived, were also disclosed. Finally, I have not had access to any files related to those conflicts, and I recused myself from any decision-making. With regard to payments during COVID, I want to share my perspective. At my first board meeting, 2 weeks after being appointed, a recommendation came forward to give management discretion within an allotted pool of capital to make assistance payments if required. No individual companies were listed in the board documents, and I previously requested a copy of that document be tabled to the other committee I testified at to show you what the board received. There was also legal advice that directors who had previously declared conflicts did not have to redeclare, and I had declared 2 weeks prior. While I understand the OAG's position on this now, at the time, I felt I was following proper legal advice. Finally, and importantly, I have not received $1 from any company that has received SDTC funds, and no company I invested in has exited or provided any return to me. I have not been compensated in any way by these companies or other organizations I'm affiliated with. I have received no payment, no dividend, and no remuneration at all. In fact, my partners and I have contributed significant personal time and financial resources to keep these companies and other non-clean tech companies contributing to the Canadian economy over the last few challenging years. With that, I'm happy to answer your questions.
Thank you very much. I'm giving the witnesses a little extra time just because I've asked them to speak slowly to ensure the interpretation is smooth. Up next, Mr. Ouimet, you have the floor for approximately 5 minutes, s'il vous plaît.
Bonjour. Merci, monsieur.
Thank you, Mr. Chair, and thank you to the members of the committee for welcoming me today. My name is Guy Ouimet. I'm originally from Montreal, where I still live. I'm an industrial engineer, graduate from École Polytechnique. I hold an MBA from McGill University. I'm certified by the Institute of Corporate Directors. For most of my career, I acted as an industrial investment professional in the fields of venture capital, private placement, project financing, and mergers and acquisitions. In this capacity, I acted as a senior executive of a private equity firm for 10 years and then launched my own private practice in the form of a boutique investment bank. This practice has developed over the years based on my multi-sector and technological expertise, particularly in energy, metals and minerals, chemicals and petrochemicals, the automotive industry, other manufacturing sectors, and among others, the evolution of these sectors towards decarbonization of the economy. My clients included institutional and government funds, as well as numerous private companies for 25 years. I participated in the setting up of multiple investment projects and transactions. Since 2020, I have been exclusively a corporate director, currently on 4 boards of directors and committee of private companies. I joined the SDTC Board of Directors on November 8, 2018, following an appointment resulting from my application to a governor-in-council recruitment process which took place over a year. Having no political affiliation and having not requested any references except those required by the validation procedures during the recruitment process, I have declared all of my background and skills. At the end of the governor-in-council process, I was recruited based on my expertise to contribute to the SDTC Board of Directors. In addition to being a member of the Board of Directors, I was a member of the Project Review Committee, PRC, and the Governance and Nominations Committee. I resigned from the SDTC Board of Directors on June 3, 2024, following an extension of my mandate. During the governor-in-council recruitment process, I declared a conflict of interest with the company of which I had been the advisor and which had been approved for SDTC funding prior to my appointment to the board. Once appointed to the board, I discussed this conflict of interest with the chair of the governance committee of the SDTC board. I received his advice and I subsequently followed his recommendations, all within the framework of governance in place. Since my appointment to the SDTC board, I have periodically declared all real, apparent, or potential conflicts. I have not had access to the files in questions, and I have recused myself from any decision relating thereto. Regarding the COVID-19 emergency payments to SDTC portfolio companies, as already indicated, the board referred to the legal opinion of Osler, which was based on the prior declaration of conflicts of interest, to the urgency of the situation and the universal nature of the measures for which no company benefited from individual treatment. Like the rest of the board, I acted in good faith in accordance with this opinion. In 2024, at the request of a parliamentary committee member, the Conflict of Interest and Ethics Commissioner investigated into allegations of conflict of interest against me. Following an in-depth investigation into the COVID-19 emergency payment to SDTC portfolio companies and considering all of my declarations relating to conflicts of interest during my entire mandate as director, the Commissioner rejected the allegations of conflict of interest against me in his report filed on July 24.
The German guy?
In the spring of 2024, the Office of the Auditor General tabled Report 6 on SDTC. SDTC management accepted the recommendations of the Auditor General and had the opportunity to provide its responses, which are presented in the appendix of the said report. Personally, I note when reading this report that no wrongdoing has been identified, that out of 90 defects identified regarding conflicts of interest management, 63 are linked to a difference of legal opinion on the COVID-19 emergency payment, and that 13 are identified as due to errors in the minutes of the meetings. I also note that the shortcomings identified in terms of project eligibility and compliance, or even governance compliance, with funding agreements and the constituting law essentially relate to the government's delays in updating SDTC's legal framework 25 years after its creation to consider the business plans and any restructuring approved annually by the Board of Directors, the Ministry, and the Minister in office. The relevance and effectiveness of SDTC have been recognized on several occasions through periodic performance audits. Furthermore, clean tech entrepreneurs praise its contribution, and venture capitalists consider an SDTC contribution as prior validation for their own investment.
You mean Liberal Insiders?
These facts are well known in the industry across Canada. Thank you. I'm available to answer your questions.
Give it to Barrett right away. Michael Barrett.
Thank you very much.
In our first round, 4 members will each have 6 minutes, beginning with Mr. Perkins.
Mr. Perkins is good still. I like Perkins.
Thank you, Mr. Chair. Thank you, Mr. Chair. Thank you, witnesses.
He's really quiet.
Mr. Ouimet, in your statement to the Ethics Commissioner and other board director testimony before this committee, found that there was a process, I think, when you were about to consider an investment. That process was a few weeks beforehand, board members would get a list of investments they would that were being considered. Board members would let the SDTC know, the secretary know, they had a conflict. And then they would be sent materials without those particular investments included in them. And then at the beginning of each meeting, my understanding is that the conflicts per director would be read out before the beginning of the meeting. Is that correct?
Mm-hmm. Oui.
Thank you. So to start off the meeting, every director knew which investments on the agenda each board member that was conflicted had an investment in, which is what you just confirmed. So the Auditor General over a 5-year period, went over 226 board-approved transactions, which was a sample of the more than 400 during that period of time. Found 186 of those were conflicted. In other words, 82% of all transactions that were coming before the board were conflicted with board members or board members had an interest. Is that correct? So you were recusing yourselves or abstaining. Board members were 82% of the time.
Monsieur le Président.
Mr. Chair, the allegations of conflict of interest were made against me last year. A detailed investigation and a complex investigation was completed by the Ethics Commissioner. All of those issues of administrative problems and...
Mr. Ouimet, that was not my question, Mr. Ouimet. I would appreciate that you stick to answering the question out of respect for members of Parliament.
Attends. De l'ordre, s'il vous plaît.
Order, please, order. To the witnesses, members here have limited time. So when you answer, it's part of their time. So I encourage all participants. One moment, please. I always give the last answer to the witness. For the next 3.5 minutes, it's Mr. Perkins who has the opportunity to ask you questions. If members from both sides think that you are not answering exactly as they wish to hear, it's their decision to interrupt you and ask you to start again.
3 minutes and 35 seconds, please.
Thank you, Mr. Chair. I will ask again, Mr. Ouimet. 82% of the time, according to the Auditor General, directors were conflicted in the transactions over the 5 years, and those overlap with your time on the board. So, Mr. Ouimet, when a board member or the committee is briefed that other board members have a conflict, do they recuse themselves or leave the room, because your chair, Ms. Vacherian, didn't know the difference last week when she testified.
Monsieur le Président,
Mr. Chair, while I was on the board, I observed that all the administrators who had declared conflicts of interest recused themselves by not being present. There were gaps in the minutes or errors in the minutes. That's well accepted. We know that. So there are errors, but that can't be.
Action, you didn't actually leave the room. So let me go over this. So you were appointed in 2019. Annette Vacherian is appointed the chair, and you went to the CEO. She testified here before committee. She testified and said that you said direct conflicts of interest are now allowed. So I'm going to join the board that I was asked to join of a company that had already been doing businesses with SDTC. Is that correct? Did you say, well, now that conflicts are allowed, it's okay for me to join that board since it's doing business here and the chair is allowing that? By the way, that was Lithion.
J'avais exercé une option.
I exercised an option in that business after informing the board, and it had nothing.
The witness is not answering the question. I asked him if he said this, and he's going to what his investments were. I'll ask that question
Point
later.
of order. Point of
I
order,
would
Mr.
like the
Chair.
witness to answer the questions I'm asking.
Just point of
Yes,
order.
Mr. Durain, yes.
I respect the fact that Mr. Perkins wants to ask questions. I'll remind him that we have interprets, and that if the witness is listening to the interpretation, it's really hard for those that are listening. It's hard on the ears of the interpreters. Merci.
Oui, merci beaucoup, Monsieur Durain.
Yes, thank you very much, Mr. Ouimet.
Here's your time. The clock is still talking. Because it is two languages here, if you could endeavor to allow time for Mr. Ouimet to hear your comments and vice versa. You do have the floor. I hear your point. We're just getting started. There'll be lots of opportunity to question the witnesses, many different directions. I'm going to turn things back over to you. You've got a minute and a half.
Mr. Ouimet, did you say, I'm going to join the board of Lithion now since Annette Vacherian is the chair and conflicts are allowed? Yes or no?
No.
No.
That the CEO lied to committee.
I joined the board, but not because Annette Vacherian was there. I didn't know Annette Vacherian.
You were already on the board. You went to the CEO. The CEO has testified that you said you would join the board of Lithion now that Annette Vacherian's on board because conflicts are allowed. Did you say that, yes or no? And it's important, and here's why.
I said no. How many times do you need no? This is no.
So you're saying the CEO lied?
I don't know what she said.
What is your 1% of Lithion worth today?
$11,000.
$11,000.
$11,000. And in that time, while you were on the board, Lithion on early 2022 got $4 million from SDTC. Is that correct?
Before I was appointed, it received $4 million.
Well, according to SDTC's records, it was in 2022 that it got $4 million. That's on their website. Are you saying that SDTC is wrong on their website?
L'investissement.
Well, there are some nuances here. The investment was approved in summer 2018 before I was appointed, and then it was provided little by little during the project. Thank you.
Suivant, we have Ms. Yip. You have the floor for 6 minutes, please.
Thank you to the witnesses for joining us today,
Ms. Yip.
especially Mr. Kukucha. I know that you're on West Coast time, so it's quite early for you. So my first question is to you. Were you the one to receive the call from a whistleblower, and when was this exactly? You're on mute, sir.
My apologies. Yes, I did receive the call, and As per my opening statement, I'm just confirming it was on January 27th, 2023.
Were you able to table the transcript of the call with this committee?
I have not seen a full transcript of the call. The SDTC staff provided me a snippet of that, but I believe either the SDTC staff has that or, quite frankly, the whistleblower should be asked to turn it over because they were the individuals that made that tape.
You've stated that you immediately advised the board and legal counsel, and at which point an investigation was started. Could you submit a timeline with dates to this committee?
The call happened on a Friday afternoon, I believe. I sought independent legal counsel that day and the following morning. I spoke to someone on the governance committee because of the sensitivity to this. There was 3 senior female executives being and board chair being accused of serious accusations. And I wanted to ensure that we manage this properly. So we set up a small committee to discuss this, and a special committee was struck immediately. And I believe legal counsel was hired by Tuesday or very early the next week. So it all happened within 3 or 4 days.
Did you submit these the findings of this investigation to ISED?
I was not in a position to submit this. I believe the vice chair of the organizations met with ISED and submitted them because I believe ISED had a parallel investigation occurring at the time.
The whistleblower told this very committee last week that the large majority of the board, maybe I think it was 80%, did not disclose their conflicts. That conflict of interest guidelines were consistently disregarded by board members and executives across every single one of the funds. As former board members, and I'm directing this question to both of you, is that factual? Is that right? And can you elaborate?
Sure, I can only speak to my conduct, and I declared every conflict, both when I was appointed and real or perceived, when they occurred throughout my membership on which was only really for 2 years that we were doing projects because of the full last year of my board work was involved with the special committee and no funding was moving forward. So I declared them all. The conflict policy was in place. My understanding, it hadn't been in place for years. So I simply was following the rules as they were laid out to me when I joined the board.
Thank you. And Mr. Ouellette?
J'ai observé, comme je l'ai.
Yes, I stated earlier, I saw that the members of the board recused themselves when they had declared conflicts. We also noted in various reports, investigation reports, that there were irregularities and errors in the meeting minutes, and that had led to administrative issues. That does not change the fact that we recused ourselves. When the ethics commissioner, investigated everything in my case, he looked at all of the documentation, saw some problems with the minutes, and asked me and others to testify under oath regarding these issues, and seemed satisfied and was satisfied that the administrators recused themselves, and that was the Auditor General who had first flagged certain things.
Before I go on to the next question, Mr. Ouellette, is there anything that you wanted to finish remarking from the previous questions?
Merci.
Thank you. I'll repeat. While we are available to answer your questions, we are not going to rehash this investigation as it has already been done by the investigator in detail. And there are questions that go beyond my legal abilities. And so I will refer back to the Ethics Commissioner, who will be able to explain his investigation, conclusions, and so on. I don't think that any of us here are, myself included, are well versed enough in the law to be able to tell you that something's wrong with the report. If you have any other questions, I'd be happy to answer them.
If I could add one supplementary piece of information.
Cheers, Savage. Appreciate
we were given instructions to be very broad in what we considered a conflict. So if we declared a conflict, it wasn't necessarily because we had financial interests. It could have been we knew someone at the company. In two instances, for me at least, it's because we had looked at investing at some point in time in the previous 5 years, but chose not to. So a lot of those conflicts do not relate to direct investment.
Thank you very much. That is the time, Monsieur. Suivant, c'est Madame Sécla Desgagnés pour 6 minutes, s'il vous plaît.
And you have 6 minutes. Thank you, Mr. Chair. Mr. Ouimet, first. The Ethics Commissioner did conduct an investigation, but I want to highlight an important point. The 4 witnesses who took part in the investigation all came here before the committee, or rather were part of the investigation and were found to be in breach of certain principles. So I ask you to respect that authority if you want us to respect yours. Over $10 million, that is the amount that the Auditor General has identified in the 8 conflicts of interest from which you did not recuse yourself. Again, this was in the Auditor General's report. So if you have a problem with the report, well, then that's a different issue. Now, looking at the email dated April 2, 2021, from Mr. Nernst, Ms. Verschern, Mr. Ouimet, yourself, you stated that you accepted an offer to become a board member, and that came into effect 30th of April, 2021. During discussions, there were some discussions regarding Lithion, but the funding was approved March 9, 2021, 3 weeks before your email. Are you saying that you had nothing to do with Lithion before, and therefore there was no conflict of interest? Inaudible to the interpreter. The funding for Lithion was approved by SDTC, was approved in 2018, in the summer of 2018, before I was appointed. Now, regarding the COVID funding, there was a conflict of interest that was, a conflict of interest was flagged for all administrators involved. And if you look at the report, there are differences in a legal opinion between the Auditor General and also outside lawyers. So with regard to my case, the Commissioner went over all of the documents, all of the minutes, and concluded that he was going to reject the allegations. He went into detailed work, and the interpreter knows that more than one person is speaking at the same time. Please stop referring back to the Ethics Commissioner's report. We have our own questions to ask. We are independent from the Ethics Commissioner, so our questions are for you. So thank you for staying specific in your answers. We have a lot of questions. Now, when you started as an administrator of SDTC or a board member, you already had links with Lithion. I was an advisor to them for the business before the funding was approved. That is, I was an advisor until 2018, the summer, and SDTC approved the funding later in the summer. Later, in the Governor and Council appointment, their separate process, I was appointed in November 2018 following that procedure. That decision for the investment had already been made. I informed the Governor and Council, the board, And I said, I will withdraw my application if it's unacceptable. And I was told, no, it's normal when people are coming from the industry that board members may have conflicts. I never took part in any of the decisions, and what happened after some decisions that were made, I was not there for those details. Mr. Ouimet, the first question, did you leave the room? You always left the room physically. In all cases, whether it's for Lithion, Nouveau Monde Graphite, New Old Graphite, Swirltex. Yes, said Mr. Ouimet. Yes, I have a list here. Yes, I can reassure you on certain aspects. For Lithion, that's the conflict of interest issue that was being discussed, and I always recused myself. I never participated in any of the decision making regarding this business. Now, for the other businesses, I had zero interest in any of them. As my colleague said earlier, those are businesses that you could see indirect links, perhaps. For example, Lifecycle, which is a direct competitor to Lithion. Well, I have no interest in that business, but because I wanted to be careful, if a competitor's case is being decided, I will recuse myself since my decision could be perceived as being biased one way or another. So I recused myself. So if you're talking about other issues, well, those are clients of a sister company. Lithion has a sister company, Soneca, and I have no links, no interest in that business, but there are some clients there. And, you know, Nouveau Monde Graphite may have the similar clients or the same clients and others. Well, in those cases, I said, these companies are related to others that I know. Therefore, I declared that and I recused myself. That's what happened. So we can't talk here. Well, you know, when you look at the COVID payments or funding, which are controversial, they added up the sums of all of those businesses as if it was a conflict of interest. It's a perception, and it was declared because I wanted to be proactive in those cases. So that's all it is. I'm not going to sink into catastrophe when there's no problem. Other questions? Okay, thank you very much.
Suivant, up next, Mr. Desjardins. You have the floor for 6 minutes. And again, just if you can speak, as you always do, slowly and clearly, please, just to assist the interpreters. Thank you. And you're on mute, sir. I've not started the time, so.
Thank you very much, Mr. Chair, and thank you to the witnesses for being present with us today in this important study. As you're both aware, it's of incredible importance to the Canadian public to understand exactly what happened with taxpayer dollars. It's important to note that there's been two incredible damages in my perspective as to how the issue of SDDC has manifested in the Canadian public. One, it's incredible damage to the sector of green innovation, ensuring that we have projects, companies, small businesses, medium businesses that actually have support from a government that wants to see real action on the climate crisis. That policy has taken substantial and serious impact because of the extreme mismanagement of the SDTC. And second, the trust of our institutions is largely compromised when it comes to at arm's length institutions outside the public service. As you know, as a member of Canada's Labour Party, I'm very concerned about the serious allegations, the HR abuses that the whistleblower bring forward, and the very serious lapses related to human resource management there. It's incredibly disappointing to know that both of your participation professionally on this has conducted itself this way, largely resolving itself to the now disbanding of SDDC outright and the ending of this chapter in Canadian history of having a third party like SDDC. So I want you to take full accountability. As board members, on behalf of Canadians, you had public trust. You were entrusted to deal with this at the utmost professionalism, and it resulted in the minister largely finally disbanding your work and transferring this to ISED, which I fully agree with, and it should have been done much sooner. I do want to now turn to the findings of the Auditor General. Mr. Ouimet, I do want to cite how important it is that you understand the Auditor General's report. In your testimony thus far, you have cited the Ethics Commission. Although we do take into consideration all work of our colleagues, whether it's in the House or in committees, including the Ethics Committee, it's important to this committee in our own study that you understand the findings of the Auditor General. The Auditor General herself is an independent officer of this Parliament and is responsible for ensuring public trust and accountability. So I'd like you to answer the questions in direct relation to the Auditor General's report. I'll return now to some beginning questions that I think are important for Canadians to understand, which is your roles and responsibilities in relation to your participation at SDTC. Can you each take approximately 10-15 seconds to describe your roles and responsibilities at SDTC, please, starting with Mr. Kukucha.
In direct answer to your question, I was a board member for a 3-year period. I sat on the project review committee, but to address your statement, if I may, Mr. Chair, with regard to HR matters that were referred to, I would say 2 things. One, at no time were any issues brought up to the board for us to consider. In fact, all reports given to the board were that there were no issues. Secondly, the independent McCarthy's report confirmed there were no issues. So whatever may be said by the whistleblower, there was an independent study done by a reputable law firm suggesting that those issues were not credible.
Well, we both know, Mr. Kukucha, like these reports, including the independent report on HR, can be sufficient to some, particularly management. But this is clear evidence why unions are important. You know, these disputes happen all the time. You can look at the corporate registry of Ontario. You can look at the corporate registry of Alberta. You can look at the corporate registry of British Columbia, where you're from. And you can see just how many labor disputes in this country go ignored, including the recent one with Teamsters. So the fact that the McCarthy report, of course, existed, the whistleblower gave us a credible challenge to that. Why not just release all of the employees under NDA then? You have to understand that these employees were subject to a non-disclosure agreement at the time of that report. And so sorry if I have to be blunt and crass with you in relation to the fact that I don't believe the findings of that report to be to be fully credible, because there was significant legal obstacle to those employees testifying truthfully because of the company's or SDTC's requirement of NDAs. So now, Mr. Ouimet, would you please describe your role at SDTC?
I was a director from November 8, 2018 to June 3, 2024, and a member of the PRC Project Review Committee and also the Appointment Review Board. Now, you talked about mismanagement.
Mr. Ouimet.
Oui, c'est ça. En effet,
That's right. And the Auditor General indicated those findings, which were accepted by SDTC and recognized. I stated in my remarks that all the findings by the Auditor General were about bad management or mismanagement and regarding compliance of projects, for example. For example, this project didn't meet the criteria, or funding agreements that are present in the SDTC funding agreements, for example. So we need to know that the board did not act freestyle outside the parameters. Each year, it's the opposite. Each year, a detailed business plan is provided to the council, to the board, approved by the members, provided to SDTC. So you could ask, why did the government not annually or periodically update the funding agreements or the legal framework? That's a question you could be asking. Now, to say...
Is the finding of the Auditor General in relation to your breaches of the Act? You know, the Auditor General was very clear that the legislation passed by parliamentarians democratically elected to help govern these programs and services, including the legislation each of you committed to uphold, was in breach. That's the fundamental issue that we're discussing today. And I understand, Mr. Ouimet, you want to balance temper between this issue and the facts.
Mr. Desjardins, your time is up. I will give Mr. Ouimet, avez-vous des commentaires briefs que vous
Do you have any comments that you want to provide? Thank you. Mr. Chair, in response to the harassment complaint or issue also, as Mr. Kukucha stated, the whole process was diligently followed. There were a number of reports. Some questioned the credibility and reliability of certain people. At some point, the minister said, well, that's enough. Enough is enough. And I will ask the Auditor General to look into this, and I will bring in McCarthy with a completely open process, with a very detailed process, to get to the bottom of the human resources issue. Well, the report completely rejected the allegations of harassment and so on. Those are issues that had to do with the board and others, but it's the report. The report has the final word. Now, the whistleblower brings up issues and problems, but the truth does not necessarily rest within their testimony. It's something to look into. Yes, we'll continue on that exact topic.
Mr. Perkins, you have the floor for 5 minutes, please.
Thank you, Mr. Chair. Mr. Kukucha, who contacted you to ask you to be on the board?
Honourable Member, no one contacted me. I applied through the Governor and Council appointment process, followed that process, and approximately, I think, 2.5 years later, I was appointed. So it was not a quick process. I thought that I could bring my skills and experience to the board and add value.
That, Mr. Rimet, who contacted you to serve on the board?
Nobody contacted me because I have no affiliation within the political government world. I applied of my own initiative when I saw that the Governor and Council process because I thought I could contribute.
Kucha, you had, I don't know if you still do, but you had a financial interest, a small financial interest in Terramera and Mia Terra, right? I think they're the same company, essentially.
Yes, I made a very small investment in 2016, which was 5 years before my appointment to the board.
And in your opening, you said that you joined the board in February 2021 and that there had been no funding of the companies, mainly this one that you had an interest in, while on the board. But according to SDTC's records on the website, on March 30th, 2021, they approved $8 million for Terramera while you were on the board.
Honourable Member, I don't recall making the statement that no funding was made. I recall essentially my understanding as I joined February 2021, my first board meeting, and I was unaware this was something that the company had applied for. They received $7.9 million, which I recused myself and I moved out of the room for that funding decision.
But in your opening, you said the only thing that was after your appointment was COVID, so now you're changing the story. And Terramera received $4.5 million before you were on the board. Can you tell me what your interest in? The Auditor General identified a conflict for you with Rotoloptic Technologies. What's your involvement there?
The company was Rotoliptic Technologies. At one point, I sat on the board of that company and I resigned from that position the moment I joined the SDTC board, and I had made an investment in them in 2017.
So you had an investment in them. And Equation Innovative Solutions?
Again, I had a very small investment in them I made in 2017. So if you see a pattern here, Honourable Member, it's most of these investments were made in 2016, 2017.
So you have an investment in them. That's good. So before and during your time on the board, those companies received almost $12.5 million, of which $8 million, more than three-quarters of that happened while you were on the board with one particular company. To me, that goes to the systemic conflict of interest we're seeing that directors had where they were voting themselves 82% of their time money for each other's companies. Mr. Emet, Swirl Tech, why was that a conflict?
I indicated to the Auditor General that I did not know the Swirl Tech company. I have no links to it, and I have no idea why it's in the meetings. We did not understand why it's a business I do not know, and that has no links to me.
Inim Inc.?
Inim.
Yes.
Inim is a sister company of Lithium, with which I have no link. That is the sister company. But I declare the perception of conflict of interest since it is a sister company of Lithium, and I recused myself. Nano One Materials, that's a company that Lithium was a part of a consortium of the nano application, so I recuse myself also.
Okay, so ENIM, which is a sister company, meaning owned or it got $3 million from SDTC while you were on the board, and Nano One got $10 million. So
yeah.
Again, it looks like a lot of conflicts of interest, of financial interest of you and your fellow directors. The Auditor General named 9 directors, some of them GIC, some of them not, that had conflicts of interest. So did it not seem unusual, since both of you are experienced directors, that have you ever served on a board where more than 80% of the transactions were conflicted when they came to the board? Mr. Emet?
I haven't done any kind of calculation as to the percentage on boards, but at each meeting where there were discussions as to this, there were 3 or 4 declared conflicts of interest, and usually it was a perception of conflict of interest, and people were very careful. It's not the same thing to actually have a conflict of interest and to have an appearance. So I don't have an interest in all the companies aside from Lithium that were declared. Thank you, Mr. Drouin. You're next. You have 5 minutes, please. Thank you very much, Mr. Chair, and I'd like to thank the witnesses who are with us today.
Start my questioning with Mr. Kukucha. Thanks again for being before a parliamentary committee. I know there's been multiple investigations, and you've been called back to another committee. You've mentioned the McCarthy review, and I'm just wondering, because we've heard some testimony from the whistleblower last week in terms of the McCarthy review, but I'm wondering, as a board member, when that was launched, were you aware that a McCarthy review was being done with employees?
The board was made aware that a independent legal firm was hired and was looking into the matter, but we did not have, or at least I did not have, visibility into that process or what was occurring. And in fact, I only saw the report for the first time approximately 2 weeks ago when I was advised I had to testify, or not even, no, last week when I was advised I had to testify.
Because there's some allegations that were, and we've asked for documentation, but some allegations were made by the whistleblower that somehow the minister would have concocted the conclusions of that report, even though it did not directly report to the minister, but another department. Obviously, when there are issues arising with whether it's an arm's length organization or the department itself, it is reasonable that that particular report would be reporting to another department. But so the board didn't have access to those documents before the McCarthy review at all, and you've just witnessed that. You've seen that for the first time 2 weeks ago. Correct?
Honorable member, I can only speak to what I had access to, and I did not have access to that, and I only saw that last week.
Okay, because I'm just wondering how it is that if a board member, and I will ask the same question with Mr. Ouimet after, but if a board member has not seen the conclusions of the report, how it's possible that somebody who works for SDTC would have access to the conclusion or seems to think that the conclusions of the report would have been somehow manipulated, And I want to remind a certain committee member that waivers were offered to employees, so the NDAs did not apply in the McCarthy review at all. So if there was allegations of harassment or whatnot, NDAs were waived with employees. But I do want to, it is important that employees are properly treated and that there's no harassment in certain in organizations or certainly SDTC, which is what we're talking about. But I'm just wondering if you had no idea about the conclusions of the report or what was in the report, did you receive any official communications from the department or from any other instances since you've resigned from the board, or would you have would you know that if your colleagues had received a previous copy?
No, not that I'm aware of, and the only communication I had from the organization was to advise of this request for testimony and to provide materials, including the McCarthy report.
Well, I don't know.
Okay,
I'm not aware. I don't know.
The McCarthy review was not prepared for the Department of Industry. It was commissioned by the Department of Industry, but in cases like this, it would be normal that the Ministry of Justice would be responsible for that, especially if there's accusations that are made, whether it's an arm's length organization that reports to a department or the department itself. So the Department of Justice was responsible for that particular report, and I find it odd that accusations would be made. And I plea again with those that are saying that the conclusions were somehow manipulated to submit evidence, because it's the only way we can move forward on this particular issue. Otherwise, we don't have documentation or proof to move forward on whether or not the McCarthy review was actually manipulated. It's just a drive-by smear, in my opinion, until I have proof. Monsieur Ouimet, je veux poser la même question envers vous. Est-ce que vous êtes...
Mr. Ouimet, I have a question for you. Were you aware of the McCarthy-Tétrault's review? Yes, Mr. Chair. During the investigation process, there first was a report commissioned by the SDTC board, and it was the Osler firm. And then we decided that it was not independent since the board had requested it. And so as the file evolved, the minister, when he asked the Auditor General to step in, also asked McCarthy to conduct an independent review commissioned by the minister. It wasn't the board since we were all being reviewed. So this review was done independently from the board. And when the report was made available and was provided to us, I don't remember whether I was on the board still, but I received the report once it was published, and we took the conclusions into account. Thank you. And I'll give my time to Ms. Sinclair-Desgagnés for 2 minutes. All right, Mr. Ouimet, you stated that you didn't know why the Auditor General had identified conflicts of interest in the case of Soltec Inc. Could you please give us some explanations? Well, yes, it's indicated in meeting minutes that I declared a conflict of interest with Soltec. I replied to the Auditor General that must have been an error in the minutes, because I have no interests in that company. I don't know them. I don't know what they do. I have no link that I can imagine with that company. So perhaps somebody declared a conflict of interest and my name was put down or something, but that's the only explanation I can give. Well, from memory, do you know who may have a link with Soltec and who could be in conflict of interest? No, I wouldn't be able to say. Yeah, no. Okay. Now, to come back to the conflict of interest issue, during your remarks, you said that you systematically recused yourself. You systematically left the room and you did not give your opinion or act in a way that would allow a company in which you have interest to obtain funding. However, the Auditor General's report stated that there were 90% of or 90 conflict of interest issues where people did not recuse themselves. So that's what we're talking about today. I know that you were called in 8 times for Surtech, but why is what's written in the Auditor General's report and what you're giving us as remarks go against each other? Why is it contradictory? Well, first, there's the issue of the COVID funding. That's, again, as stated previously, it's a difference of legal opinion. The conflicts that we declared before the COVID funding issue were looked at as by the Auditor General and will be seen as a conflict because, we received the COVID funding with those decisions pending or in the background. Now, there are other examples where it's very clear that the minutes of the investment committee, for example, that Mr. X or Ms. Y declared a conflict of interest. But the practice is that when a director declared a conflict of interest, they would recuse themselves and leave the room. However, the minutes did not necessarily indicate all of those details, did not necessarily indicate that Mr. X left the room, came back to the room. It simply stated this person declared a conflict of interest. And the Auditor General would state that I have no evidence indicating that so-and-so left the room. So that's why I was saying earlier that with the Ethics Commissioner, we explained all of this, and he heard from certain witnesses and was satisfied. I understand that you're conducting your own study, but I can't change the facts. The administrative problems have been recognized. Thank you very much.
Please.
Thank you very much, Mr. Chair.
Yeah, Blake.
I do now want to turn to a finding of the Auditor General's report. Can you both please confirm whether or not you've read the report and agree with its findings? Yes would be fine as an answer, or no. Mr. Kukucha.
I have scanned the report, and it speaks for itself.
Do you agree with the report?
It speaks for itself.
Mr. Kukucha, I think you can probably reason with me to suggest that that's not an answer to whether or not you agree with the Auditor General's report. Do you agree with the independent findings of Canada's Auditor General?
As I stated in my opening statements, there were shortcomings were laid out, and they speak for themselves. So
would it be okay to say you partially agree then, or do you outright reject it?
I take it for what it is. It's a report of the Auditor General.
Mr. Ouimet, do you agree with the findings of the Auditor General?
La direction de SDTC a reconnu.
The board of SDTC recognized the findings of the Auditor General, provided its responses in an appendix, and I read the report, and we have to accept it. And the report presents a certain point of view. That's it.
Mr. Ouimet, I understand that these topics are sensitive to each of your professional and personal lives, but you have to understand that this is a far greater concern. The issue of you're largely challenging whether or not the Auditor General is telling the truth in fullness, and that is a problem for me as a member of this committee. If that's not what you're saying, then why not accept the findings of the Auditor General?
Go ahead.
No, I'm not challenging the Auditor General or saying he's lying whatsoever. In fact, the Auditor General on several occasions in the report that I saw, gave credit to the way we dealt with the whistleblower in the special committee, advised the board was not advised of things at certain times. So yes, I accept the report for what it is, but I also believe that facts and context matter. So to the point that Mr. Ouimet brought up earlier, some of the numbers that are presented in a way that suggests that there was arguably a more systemic problem that there may have been. But I accept the report and take it on its face.
Well, it's certainly a systemic issue. by a large margin. This has been going on with SDTC for a long time.
Let me just interrupt. Do you want to hear from Mr. Ouimet again? I without any commentary from you, I'll allow a response from him if you would like.
Please, no. If anything of importance, Mr. Ouimet, to the report.
Of a toward Mr. Ouimet.
No, les faits nous ont été présentés.
The facts were presented to us. We had the opportunity to discuss it with the Auditor General and to provide our comments. The board had the opportunity to respond. You know, we're not challenging the Auditor General's report once it's been tabled. We could provide context for certain points. That's what we're doing here today with you, because the Auditor General, if you allow me, is not there to provide much nuance. The Auditor General is there to be, look, there are problems with meeting minutes that don't clearly state that somebody recused themselves because they declared it, but it wasn't stated that they recused themselves when they did in reality. So that's, one problem that will be flagged. Perhaps that person has a very indirect link with a company, no interests at all. Now, is that a conflict of interest? Is that a fraud, a violation? No. Those are administrative errors. And thank you.
Up next, Mr. Cooper, you have the floor for 5 minutes.
Yes, MP Cooper.
Thank you very much, Mr. Chair. Mr. Kukucha, in your opening statement, you said with respect to the improper COVID payments, of which 38.5 million tax dollars improperly went out the door according to the Auditor General, not to mention 63 conflicts of interest involving board members in which millions were funneled into companies in which board members had interests in, you said that you relied in good faith on legal advice. Is the legal advice that you as a member of the board received from one Mr. Ed Vandenberg?
Sorry, I was muted by the host. Yes, it was, Honourable Member.
Okay. The same Ed Vandenberg who sat on the two-person SDTC member council, correct?
You're correct, Honourable Member.
Yeah. So you're a lawyer, Mr. Kukucha, through you, Mr. Chair. Do you not see a conflict there that Mr. Vandenberg sat on the member council while at the same time providing legal advice to the board and being remunerated for such service?
There were discussions at the board about the structure of the member council and the challenges with it, and my understanding was management was trying to work with government to try and find a way forward with that. But yes,
Mr. Vandenberg had been providing legal advice to the board on other matters as well. It wasn't just in respect of the improper and unlawful COVID relief payments, right?
I keep getting muted. I apologize, Honourable Member. Yes, he was providing advice, and I do.
Thank you for that.
Mr. Cooper, just 1 second. So I'm sorry. I think what's happening is that when a witness is done speaking, we return to a member. You're being muted. So if you could just unmute yourself to both witnesses, avant que vous parlez, s'il vous plaît. If you could unmute yourself, that's what's happening. So. It doesn't always happen. I think it's because of just the. Well, anyway, for today, that's what has to be done. So, Mr. Cooper, you have 3 minutes, 15 seconds. The floor is yours again.
Mr. Kukucha, have you read the SDTC's enabling legislation, the Canada Foundation for Sustainable Development Technology Act? I presume you have.
You do need to, as I said, you do need to unmute yourself, sir. Back to you. There you go. Yeah, over to you.
Honourable Member, I have not read the entire act. I have read the policies related to SDTC.
Board member, as a board member, surely you were familiar with the enabling legislation. I mean, I find it incredible if you weren't. I mean, that's a big problem in and of itself.
Sorry, I keep getting muted. I apologize, Honourable Member. I have a general overview of the legislation, but I have not read it in detail.
It sure isn't actually a very big piece of legislation. It would take all of 15 minutes to go through, and if you had bothered to read the act, you would have known that at section 16 sub 2 it states, quote, no member shall profit or gain any income or acquire any property from the foundation or its activities. That's precisely what was happening in the case of Mr. Vandenberg. So not only was he in a conflict of interest in providing legal advice, he was breaking the law. Isn't that right?
Based on your statement, Honourable Member, I will take it at face value. I would only comment that once we got into the special committee process, I actually did flag for the board and management the issue of Mr. Vandenberg and ask he be removed, but he was not removed at that time.
So, again, conflicts of interest, money improperly going out the door, and reliance supposedly in good faith on counsel who was in a blatant conflict of interest and who was in blatant contravention of the SDTC Act. I mean, it's just unbelievable that you can come here with a straight face and defend the practices of SDTC and its board in the face of that. And speaking, Mr. Kukucha, of law breaking at SDTC, which you were complicit in, Mr. Vandenberg was part of a two-member council, a council that under the Act is required to have 15 members and requires 5 members to achieve quorum, and yet this two-person council appointed 5 directors to the SDTC board, all unlawful appointments. How do you explain that?
Honourable Member, when I joined the board, this system was in place and operational for many, many years. I did flag, and the board did have discussions.
In fact, the Auditor General, in her damning report, which you won't even concede or accept, said that the board that you sat on was complicit in this illegal activity. The board supported the law breaking. Isn't it part of a culture of corruption, self-dealing, and law breaking? Isn't that what was going on? Because I would say to you, Mr. Kukucha, it raises serious questions about why the board would have been complicit in having an unlawful two-member council. It was all about making sure Liberal insiders and cronies of board members were appointed as directors so that they could get a piece of the action to pad their pockets in a corrupt racket that makes the sponsorship scandal look small by comparison. That's what happened.
Hear, hear.
You have the floor, sir, if you'd like a response.
Yeah, Honourable Member, I can only speak to my own conduct. I did not have, there was no corruption that I directly saw or was aware of or participated in. Errors were made. We acknowledge those. I did accept the results of the Auditor General's report, and candidly, I did flag for the board issues with both the Members' Council and Mr. Vandenberg, but they were not acted upon. As a new member to the board, all I could do was my best to raise issues, see if they were dealt with, and try to move the organization forward in a positive way. But I will concede errors were made for sure.
Thank you very much. That is the time. Mr. Erskine-Smith, you have the floor for 5 minutes, please. Over to you.
Thanks very much. I want to stay with you, Mr. Kukucha.
Who the heck is this
guy? You mentioned that you flagged a concern with Mr. Vandenberg or his involvement and his role. I'm just trying to work out a timeline. I'm new to this committee, so when did that take place?
Are you new to Parliament?
That took place in a discussion related to the special committee later in 2023. I don't know the specific timing, but it was flagged and no action was taken.
And again, just so I'm clear on timeline here, so you received the whistleblower call.
Sorry, Mr. Erskine-Smith, I'm going to give you your time back here. Just give me 10 seconds. Just hold on a second.
Sure.
So just to follow up on the request, we have 2 individuals now, a member and a witness, who are having a back and forth. So I really can only have one microphone open at a time. This is true even when it's on the floor here. So when Mr. Erskine-Smith's microphone is open, I'd ask the witnesses to be sure they're muted like that. And then when the member's done, take a second or two, and then over to the witness. So back to you, Mr. Ernst Smith. I did pause the clock. You've got just over 4.5 minutes.
I appreciate it. All right, we'll dance with the microphones. Okay, so just again back to the timeline. So in January 2023, you received the whistleblower's call. I expect we'll get a transcript of that at some point, although you would only have a partial one, or STCC would have some staff there would have a partial one. But you then, the board initiated a special committee, which then came back with a report from a law firm in May 2023. And just so I'm clear, that law firm was Vandenberg's law firm?
Yes, it was. And to be clear, that was ultimately a mistake. We should not have hired them in the sense that Mr. Vandenberg was on the members' council. We were very much focused on moving an investigation forward quickly, and that recommendation came forward, and the committee and management were very supportive of that. And in hindsight, it was a poor decision, so I will absolutely concede to that.
No, understood. I appreciate that. So what did that report tell you, though? Did the law firm flag the same concerns that we then see through the Auditor General's report, or where did it differ?
Well, so I'm going to look at my notes for that investigation. We did not have, nor did the lawyers have, all the information from the dossier, which we had requested from the whistleblower. That report, if I can find it, I apologize. Did a series of investigations and interviews with employees based on the allegations we had from the 1-hour phone call, including an extensive document search, and it did not find any systemic issues. But then I do not believe we had all the facts which were available to us and available to the government in the dossier.
So obviously, though, there was enough concern in that hour-long phone call that you brought it to the board, and a special committee was initiated. What was, in your view, the most damning allegation that the whistleblower brought forward in the course of that phone call?
There were baskets of allegations, including misappropriation and misuse of funds, HR allegations. They were all serious enough to be looked at. But anytime government funds there was an allegation about misappropriation of government funds, that was absolutely the one I took most seriously. And I took them all seriously, but
understood. I'll pause you there, and if you can turn your mic off. When it comes to misappropriation funds, because I think it's useful to separate it from that concern from the HR concerns. So I've read the AG report. I've read the Ethics Commissioner reports, but specifically around the Verschuren report. And the Ethics Commissioner does find that there are two violations there. That one, abstentions should have been recusals, and two, that blanket approval of COVID relief was improper, that there should have been recusals there as well, and there was an improper furthering of a private interest in that case. I didn't see any allegations or concerns of misappropriating funds. Were the whistleblowers' concerns in that regard more specific, and have we not seen them studied by the AG and by the Ethics Commissioner in the same way?
There was no specificity to the whistleblowers' accusations around misappropriation of funds. And as I said earlier, the AG's report stands on its own with regards to its details and findings. So.
Okay, and my last question is in relation to the COVID payments, which I think Mr. Cooper overstated, but my understanding from the AG reports is 63 approvals in a bundle for about $12 million. Regardless, a significant sum of public funds. And we have one case where the Ethics Commissioner has now found that there was an improper furtherance of a private interest because the chair did not recuse herself, as she said she would actually when she was first put in that position. Regardless, what was the legal advice? I've heard that different legal advice has been provided, and so people weren't recusing themselves at that time. What in the world was the lawyer telling you, that a recusal wasn't necessary? What was the legal rationale?
The legal advice was that because we had previously declared conflicts and this was funding that was being provided in a basket to management to use at their discretion to top up if there were financial concerns was that we did not have to recuse ourselves again if we had previously declared that conflict.
And the same lawyer.
Yes, correct, Honourable Member.
Thank you.
Thanks very much.
Very much. That is the time. Beginning our third round, Mr. Cooper, you have the floor for 5 minutes.
Thank you, Mr. Chair. Mr. Kakucha, you said that as a member of the board, you didn't even bother to read the enabling legislation, which would have taken all of 15 minutes. Did you take the time to read the contribution agreements with ISID? My time is...
Sorry, that was direct question for Mr. Yes, Mr. Kakucha, did you catch that question, or is your... He might be frozen.
Just stop that.
Yeah, we'll just suspend here for a second.
I guess they're having that audio trouble again. They've been having that all committee
Pulling
so
in
far.
a net for Sharon.
Here, I'll suspend the meeting until we can see if we can get the witness back.
Oh, what? His camera just magically decided to go out. He doesn't like the questions from MP Cooper, so now all of a sudden he's having technical issues. I don't believe that at all. I don't believe that for a second. Exactly. Yep. Yeah, he's frozen in fear. Time for technical difficulties. Exactly. That's funny. Because Cooper has receipts. Exactly. Exactly. What's interesting about Cooper, too, is you'll notice he's constantly got a pen and paper beside him, and he's listening to everybody else's questions, and he's constantly remembering and writing down what he wants to do for his questions. So when Perkins was talking in the first round, he added up all the money that Mr. Perkins asked about in the conflict of interest with these guys' own financial interests in the companies, and it was something like $35 million. So just between the two of these guys, they've been conflicted with multiple different investments while they're chairs of this fund, and it's already totaled $35 million. I'm sure it's more. I'm sure those are just the only companies that we know about. So as you can see, we got another liberal hack in the chat. It's fine, guys, as long as people don't spam the chat, I'm more than fine with people being entitled to their own opinions. I don't agree with, silencing people. That's the whole point of politics, is to have your discussions. As long as you're not like Fang, for example, who, like that, one of the bots from like China that just comes in and just spams paragraph after paragraph after paragraph in the chat. That's fine. Morning in, Luca. They're just on a break for a second here. They're having audio troubles. As soon as Mr. Cooper's round is on, all of a sudden the guy's frozen and he's having technical difficulties. Yeah, exactly. Same. I agree. Free speech, so you can have your own opinions. It's totally fine. That's what politics is about. You don't have to necessarily agree with the other person, but they're entitled to free speech and have their own opinion. So as long as they're, keeping the chat friend, like, I don't know, just not spamming the chat, That's really all I care to censor. Morning, Suzanne. Welcome in, guys. I can't imagine they're going to be suspended for too long. They're just doing their thing for a sec here. And also, I find a lot of people over the last 9 years, for example, of Trudeau, have lost faith in politics in general. So it is good to watch committees like this and to watch how Liberals handle themselves, how NDP handles themselves, how Conservative handle themselves, because it's good to see not just stuff in question period, but it's good to see committees and how not just the Prime Minister or Pierre Poilievre, leader of the opposition, handles themselves, but how everybody else in the party handles themselves. Like, we all love MP Cooper, we like Michael Barrett, we like Larry Brock. These guys are really good. These guys are really good MPs. Representing their constituencies for sure. So while we wait, we can actually watch one clip for a sec here if they're going to take too much longer. I got a good clip we can watch. Let me see if there's anything that's happened recently too while we've been live in committee. Yeah, I agree. It's interesting to see that the Liberals say they're talking to so many Canadians and things like that. I mean, I don't know who they're talking to because even some Liberals just don't have trust in the government and stuff. So I don't. Yeah, I agree. Silent Night, definitely, he was a solid prosecutor for sure. Crown attorney. All right, let's tune into a clip here while we're waiting. I'll try and pull up something good here for a sec. Oh, this is a good one actually. Let me grab this one. Okay, so this is really important to understand.
I just want to look. Just
sorry, let me change the audio a bit because this is going to be a bit loud.
Let's stay on the bank losses for a moment. I think so. 22-23, the loss is $3.1 billion. Is that correct?
For 5 minutes, please.
Thanks very much, Mr. Chair. Ms. Rogers, you gave a speech a little while ago about productivity, and I just want to make sure I totally understand what productivity means, because I know there's a lot of jargon and term that gets thrown.
Okay, so just before we watch this, a little preamble is this is MP Scheer, and they're talking to the Bank of Canada governor and the deputy governor, and just really important here, what I want you to understand is how bad we printed money during COVID, because we're talking about STTC here, right? And we're talking about COVID payments, so it's kind of related, is how much money actually was printed, just straight up through government bonds. And it actually took the Bank of Canada into a negative, bankrupt position for the first time in its history. It's never been like that before. Only Justin Trudeau could do something like this, so just listen to Scheer.
Run around here, but productivity, as I understand it, is how much Canadians produce, how much trees they turn into lumber, how much grain they grow, how many cars roll off the assembly line. It's basically the things that individual Canadians make. Is that correct?
Yeah, as a function of the inputs it takes to make them. Yeah.
And I think you also said in your speech that low productivity has a negative effect on inflation. In other words, low productivity will have the effect of having higher inflation for longer if Canada doesn't start to produce more. Is that an accurate summary of?
Not exactly. What I said in my speech is that improving productivity would.
Can you think of some things that would, in other words, policy, would investments in capital also help with productivity?
Yes.
So would things.
Where is it?
My understanding is the Bank of Canada ended that program, but you do act as the the financial agent for the Government of Canada to purchase these bonds. So the Government of Canada will now own mortgage debt as a holding?
My understanding?
Yes, what we're doing exactly is we're basically borrowing money in order to buy finance those Canada mortgage bonds. So basically we own some of that debt, yeah.
So the Government of Canada borrows money to buy mortgages from banks who have lent money to Canadians? Is that?
Thank you for your question. Basically, the way it works, CMHC basically borrow money in order to buy NHMBS. So those are pool of mortgages that are put together. And when you look at the market, the way it works, CMHC, when they were issuing and they're still issuing, there's a spread relative to the Government of Canada debt. So when you look at the debt that the product they're issuing, they're fully backed by the Government of Canada, so they should be issuing around the same rate, right? They're a AAA product. And because of that spread, the government decided to issue its own debt in order to finance the CMBs. So the debt that we're issuing, it's debt that basically CMHC doesn't have to issue on the market.
It's guaranteed by the government itself, right? So the government is both the backer of the debt and now the holder of the debt?
That's horrible.
Prior.
So that's one clip. There's a better one where I just made it into a short. As you can see, the committee is still adjourned. I wonder what's taking them so long. It's actually quite annoying. But this one's pretty good. So this is just like a highlight.
I just want to make sure I fully understand the loss and who's on the hook for the loss. So the Bank of Canada has an obligation to pay in interest payments money to the large financial institutions that have accounts at the Bank of Canada. It's now paying more in interest than it's receiving from the Government of Canada for the rate of the bond itself. And what you've told the committee is that barring any legislative change, which is hypothetical, in real terms, that loss has to be covered basically by the taxpayer. Is that correct?
So we do need a solution, but what I'm telling you is that the bank will make losses for a period. It will go back to profitability. So provided we can use those profits in some way to
but today you can't,
to
right?
fill in the deficit. Yes, today.
So I just want to make sure I
So that's what I was trying to show you in that other clip, is that essentially during COVID, the government needed to fund federal spending, which, again, if you guys have ever taken a basic economics class, Economics 101, you learn in history how Greece did that, how Venezuela did that, and how it triggers inflation. When the monetary bank prints money to fund fiscal spending, those two are never supposed to conflict, which is exactly what we did during COVID, because obviously it was unprecedented times. Even Stephen Harper did say that it's not like he would have taken that off the table. He would have considered that as an idea because there's less tax revenue coming in and stuff, and the government still needs to operate under some sort of money coming in. So it's just a threshold in the level that we printed money. It was such an exceeding level that it's never talked about in the House of Commons. Trudeau will always try and deflect that it's the war in Ukraine, even though we do less than 2% of our global trade with Ukraine. Most of our trade, as you guys know, goes to the United States. Trudeau will try and say it's because of global other issues. You know, the world's going through inflation, guys. It's not just Canada. It's basic economics. It's the first thing that you learn in economics, is that you never use the monetary system to pay for fiscal spending. They're two different things. And it's just, I mean, we printed something like 17% money supply, M2 money supply, in a matter of 3 years, which we usually only do 3 to 4% a year. So that's, 17% a year times 3 years, when you're only doing 3 to 4% usually, is a huge increase.
Yes, Mr. Chair.
Perfect. Puis Mr. Ouimet, ça va aussi avec vous?
Mr. Ouimet, it's fine
okay,
for
so we're
you
back on.
also? Yes, very well. Okay, thank you.
Mr. Cooper, you have the floor for 5 minutes, please.
Thank you very much, Mr. Chair. Mr. Kukucha, you said you hadn't bothered to read the SDTC Act, which, if you had, you would have realized that the legal advice you were receiving and the board was receiving was in contravention of the Act. Have you bothered to read the contribution agreements with ISIT?
And honourable member, as I was started in my last answer, the contribution agreements were negotiated between management and the companies. So they were all individual to projects.
You
so we did
sat
not
on
have
the
access
board.
to them.
You sat on the board, and you were voting yes or no in respect of funneling money out the door. And had you bothered to read the contribution agreements, you would have learned that when you voted to approve millions of dollars in COVID funding, putting aside the conflicts of interest, that it was also in contravention of the contribution agreements with ISIT. But you didn't bother to read those agreements, did you?
Honourable member, the COVID approvals that were made, the second COVID approvals, I was only on the board for the second COVID approvals, came to us with a blanket set of funds with no list of companies to give management discretion. And when I asked management whether or not this was in, because I specifically asked the question, and other board members did as well, whether or not this was in contravention or whether or not it was approved by government. Management confirmed it was approved by government, and there was no
of the
dissent
contribution agreements. And you said, or at least Mr. Ouimet said and Ms. Verschaeren said in their testimony, that the board approved those funds because SDTC's portfolio companies were struggling during COVID. But you know, sir, that isn't true.
Honourable member, I do know a lot of companies were struggling during COVID. So we took it on face value that management had canvassed all the companies and had
face value, sir.
Information.
Sir, through you, Mr. Chair, it's my time, reclaiming my time.
Order, gentlemen. As I said, we're trying to safeguard the interpreters here as well as maintain decorum. Mr. Cooper, you have the floor, please.
The whistleblower testified that at the time of the second tranche of the improper and unlawful so-called COVID relief payments, of which you were then on the board, SDTC had completed a full survey of the total portfolio of SDTC companies and found that every single company on average had over 14 months of runway, proving that the companies that received the money didn't need the money. You would have seen that analysis, wouldn't you have?
Honourable member, we did receive the analysis. I can't speak to the specific facts you mentioned, but there were concerns with supply chain. There were concerns with a number of issues, and even companies that I was involved with that had no involvement with SDTC were deeply concerned about those. So
14 months of runway. 14 months of runway, and the money went out the door. It, sir, had nothing to do with COVID relief and everything to do with funneling money into the companies in which board members had interest. And that's what really was going on. Mr. Ouimet, when you last appeared before this committee in December, you stated that at SDTC, quote, the conflict of interest management procedures are rigorously followed. Do you stand by that?
Absolument.
Absolutely. The procedures have been respected, but the documentation did not reflect it at certain points, and it was recognized by the Auditor General, and it's been noted.
Mr. Ouimet, you keep claiming that the minutes were the problem, not that there were conflicts of interest, not that money improperly went out the door, that there were inaccuracies in the minutes. But Ms. Lawrence stated, and I'm referring to paragraph 69 of the Verschaeren report, in which Ms. Verschaeren was found guilty by the Ethics Commissioner, that with respect to the minutes, they were carefully reviewed and amended internally where necessary and should be considered accurate. Is Ms. Lawrence wrong? Is that what you're saying?
Je ne peux parler que pour moi-même.
I can only speak for myself.
I didn't hear
Yeah,
the answer.
he said he can only speak for himself. You have a small question time remaining, Mr. Cooper.
Well, I'll ask Mr. Ouimet if you would apologize to Canadians for the conduct of the board. 186 conflicts of interest, $38.5 million in COVID relief payments that improperly went out the door, millions of which went into companies of board members. Would you apologize and admit that that should not have happened?
Non, je reconnais les...
No. I recognize the findings of the Auditor General, and the statements of the honourable member are false.
That turns us now to Ms. Bradford. You have the floor.
You should read the Auditor General's report, and he should read the ethics
Order,
commissioner's.
Mr. Cooper. We've moved on to Ms. Bradford.
I agree, Mr. Cooper.
Thank you, Mr. Chair. And thank you to both of the witnesses for being with us today. I realize that you've been before committee before, so I thank you for coming back to this one. Mr. Kakucha, I was wondering, your opening statement was very, very detailed, and my shorthand isn't what it used to be. Would you mind providing that, a printed copy to the committee so that we have that for the record and can review it?
Honourable member, a printed copy was sent to the committee late last evening.
Oh, I see. Okay, I don't think we got it.
If I may, though, honourable member, there was an allegation that I actually changed my comments in testimony from the opening statement, and I just want to correct that for the record. I stated that the vast majority of funds that these companies received were provided prior to my joining them to the board. So I do not accept Mr. Perkins' allegation that I changed my testimony, honourable member.
Okay, thank you for that clarification. So were the McCarthy review findings shared with SDTC's board and its employees?
As stated previously, honourable member, I only received them last week.
Oh, right, okay. Now, I think many of us around this table are having trouble understanding some of the board's conflicting practices during Mrs. Verchoeven's chairmanship. The AG has found that in 96 cases where $260 million was approved for funding, board members appropriately disclosed their conflicts and recused themselves. But in 90 other cases, worth $76 million in funding, members didn't recuse themselves properly in cases of conflicts. So I'm going to address this to each of our witnesses. Can you please explain the difference in perception between perceived conflicts and actual conflicts? We're wondering why there's this discrepancy in how the board members conducted themselves. So if you could maybe explain the discrepancy in following the organization's policies and what you view as the difference between a perceived conflict versus an actual conflict of interest.
I can only speak for myself, honourable member, in that an actual conflict would be where I have or I had a direct investment. A perceived conflict would be where I had a relationship within the company or some connection to, or we had reviewed the company previously. So that is how I interpreted the difference between those two matters.
What would your answer be?
My answer is the same. In my case, for example, one conflict of interest, a single one, where I had interests in a company. In all the other cases that were mentioned in the files were related to perceived conflicts of interest, which I declared to be forthright, as was recognized. Something that could lead to a perceived conflict of interest, and that was the case for many directors.
Okay, so continuing with you, were you ever asked to resign from the board of a company that you had previously received SDTC funding?
No.
No.
And how and to whom did you disclose any real or perceived conflicts during the GIC appointments process and once joining SDTC?
j'ai déclaré
I declared my conflict of interest to the Governor and Council in the documentation, in the initial documentation, the application forms, the various documents that are requested. And I even declared it in my submission letter, along with the letter, with the forms rather. And after that, I discussed the issue when I was appointed to the board with SDTC board members.
Okay, and I have the same questions for you, Mr. Kuchia. Were you ever asked to resign from the board of a company that had previously received SDTC funding?
Honorable member, yes. As I stated in my opening statement, there was a company called Rotolyptic that I sat on the board of that I was asked to resign from as part of the GIC process, and I immediately resigned.
Okay, thank you. And how and to whom did you disclose any real or perceived conflicts? So you just answered during the GIC appointments process, but once joining the SDTC?
The process to disclose, once we were on the board, was prior to every meeting. We received a list from management, and we sent our responses back to management collectively and to the entire board as well.
Okay. I did wonder, I was wondering if, Mr. Ouimet, last week we heard that due to funds to companies needing to be approved by the board, oftentimes there would be many bulk approval processes where the applications were not even reviewed unless a board member had a specific question around any of the applications. Can you tell us a bit more about this bulk approval process and how these tranches of funding were allocated in such a way?
Oui.
Yes, Mr. Chair. We instituted a few years ago a type of funding called seed funding, which was about $100,000 per companies, so much smaller than the usual amounts for startups. And there was a specific process put in place by management and approved by the board, and that was to have a jury approve each project on behalf of TRC, and there were external experts, representatives, and possibly a member of the board that took part in these juries. That was across the country. We approved a number of applications, 10, 15 of them perhaps, for seed funding. And once it was approved, it was submitted, knowing that the process had been done by reputable people. And that is a practice that we see in other federal and other funding processes. Next is Ms. Sinclair Degagny for 5 minutes. Mr. Ouimet, who were the reports and the minutes of the board meeting sent to? Well, the minutes are sent to the directors, all of those who were there, and they were surely made available to ISAD representatives since they were there with us, or they knew that we were holding these meetings. So you never noticed that there were errors? Well, I always read them, and I recognize that there were errors that I may have missed. I mean, there are two types of error. For example, post-rule text, which is a real error that slipped through without us. For swirl text, you didn't notice? You didn't notice? No, I did not notice, but I did read the minutes quickly, but I did miss that. In other cases where errors were noted by the Auditor General, if, as I said earlier, if Mr. X declared a conflict of interest, but I saw in the minutes that it didn't say whether they had left the room or not. But the fact that it had been declared told me, I knew in the context that that meant that they had not taken part in the decision and that they had left the room. I understand what you're saying on that, Mr. Ouimet, but we're really trying to understand the situation. But now you're telling me that in your case, it's enough to, in case of conflicts of interest, it's enough to simply declare it and not leave the room. So what you're saying is that, excuse me, I just want to finish. In the 8 cases of conflict of interest that we see in the minutes that we saw that the Auditor General flagged. She didn't pull that out of nowhere. There were 8 cases minimum where you missed a very important point, for example, that you recused yourself in a real conflict of interest, and you missed the point that you were told that you were in conflict of interest for a company. You missed all that. So did you not live up to your role as director, Mr. Ouimet? No, I regularly and periodically reviewed the meeting minutes, and each time I noted that I had declared a conflict of interest. I know that I recused myself. I left each time. I never stayed in the room. That was not my question. The interpreter knows that more than one person is speaking at the same time. It was your job to review the minutes and to show that and to flag it if there were any errors. That was part of your role as a director. Well, since the beginning of this whole exercise, we've recognized that there were errors in the documentation. Quick question, Ms. Sinclair Degagné? No?
Very much. Suivant, it is Mr. Desjardins. You have the floor for 2 minutes.
To the members, to the witnesses, within the Auditor General's report, it found that the SDTC board did not ensure SDTC's compliance with the enabling legislation. They also found that the board did not follow the process required by contribution agreements to approve the funding. These are pretty damning statements by the Auditor General. To evidence this, in her finding under 6.27, for the 58 projects described in paragraph 6.21, we reviewed and analyzed the materials that Sustainable Development Canada or Technology Canada had used to screen and assess projects for funding. This included budgets, corporate information, risk assessments, external expert reviews, reports, and materials and minutes of the related meetings of the Project Review Committee and the Board of Directors, to which both of you are members of respectively. We found that 2 ecosystem projects were clearly ineligible as they did not fund or support the development or demonstration of a new technology. While they did not perform a technological assessment of the projects, the Auditor General also found that 7 startup projects and 1 scale-up project were, in their view, the Foundation's documents did not demonstrate the eligibility criteria were met. Largely and overall, these 10 projects were approved for $59 million in funding, of which $51 million was dispersed at the end of our audit period. The AG found that 10 projects totaling $59 million in funding were approved despite not meeting eligibility criteria. Was the board made aware of these projects, the fact that they did not meet eligibility criteria? Mr. Kukucha.
Thank you, Honourable Member. My recollection was the ecosystem projects were approved prior to my joining the board. The one ecosystem project I recall reviewing was the Verscheren Center, which we actually turned down at the Project Review Committee. I know myself and other new board members had questions about that program that we asked at the board.
So that's a big red flag, you'd say.
We asked questions at the board, Honourable Member, about that because we could not find information online about that either. So we probed management with that. And again, as in some other matters, we were assured by the CEO that this was approved by government and there was written confirmation for that.
So you just trusted the board, Chair?
Well, we trusted the management and CEO that ran the organization, and we believed that if there was a different view, the ADM who was sitting in the room from government would have either approved or contradicted that. But there seemed to be unanimity that this was aligned with the purpose of the organization.
The ADM being present gave you false concerns that they were approved or passed the line?
At one point, there was a verbal confirmation, and other points there was no verbal dissent. Correct.
Thank you very much.
Thank
that
you.
is the time. I turn now to Mr. Nader. You have the floor for 5 minutes, please.
Thank you, Mr. Chair, and now I'll be splitting my time with Mr. Perkins. I just wanted to get a few questions of clarification on the record to you, Mr. Kukucha. The January 27th conversation of 2023 with the whistleblower, how did that occur? Was it over the phone, or was it on Zoom or some other platform?
The whistleblower contacted me, and it was an unknown number that came up on my phone. I picked it up. I was at the end of a meeting, so I requested they call me back approximately 45 minutes later or something such as that. When I was in an environment where I could take notes and be attentive. They called me back, and then an hour-long conversation ensued after that.
Clarification. So, to your knowledge, then, prior to this conversation, had you had any dealings with this individual?
To the best of my knowledge, Honourable Member, I did not.
And to clarify, then, are you of the opinion that this was the same individual, witness one, who testified before this committee, or a different individual?
As I stated in my opening comments, it appeared to be different just because of the tonality of voice. There was something in the voice of the two individuals that appeared very different for me, so that is why I made the statement that I did.
Clarification. And last question on this matter. You did note that you made contemporaneous notes of that conversation. Would you be willing to provide those notes from your conversation to this committee?
If the committee requests them, I would happily turn them over.
Okay. Well, I would personally request it as a member of this committee, but we can deal with that as a group committee later.
I'll just pause. I don't think that's necessary. I think, is that something you prepared to do, Mr. Kakucha, pardon me, or on the request, or would you prefer we pass a motion on that?
Mr. Kook.
I don't, Mr. Chair, I'm not sure the law around it being compelled to provide information by parliamentary committee versus my former duties as a board member. So I'd either need to seek legal counsel on that, or I would defer to yourself passing a motion to require that. But I'm prepared to do whatever this committee requires me to do.
Let me come back to you on that. So, Mr. Nader.
That all passed my time to Mr. Perkins.
Thank you, Mr. Chair. Mr. Kakucha, earlier, how much was your initial investment in Terramera?
In 2016, I made a $15,000 investment, Honourable Member.
And what is that worth today?
Honourable Member, I do not know. This is a private company that, and I'm cautious because it's a private Canadian company trying to do good work. I know they went through a split of some sort, so I could not tell you what that's worth today.
How about Rhodolyptic? What was your initial investment there?
My initial investment there, sir, was $200,000.
And what's that worth today?
Again, as a private company, I do not know the valuation of that, and I would not want to speculate, but let me say that I don't think either company has, I think both companies have seen challenges over this last couple of years. So like anything with venture capital, these are risky investments.
And Echo Asian Innovative, if I'm pronouncing that right, how much was your initial investment?
Again, it was a very small amount of $15,000 in 2017.
And I assume the same thing on current valuation?
Correct, Honourable Member.
Okay. Mr. Chair, I would like to move a motion right now, if I could.
Just hold on. I'm going to deal with this matter with Mr. Kakucha. Mr. Kakucha, here's how we generally proceed. The request has been put to you. You seemed agreeable. If you could check then on your ability to provide us those notes. If you cannot, for legal reasons, please get back to us. As I'm sure you know, the committee can move to have you submit them, which then elevates it, and then there are other steps after that. We don't normally go from 0 to 60 at the first blush. We don't typically need to do that. As I said, you seem to be agreeable. So if you could provide those notes or get back to us with a detailed explanation as to why you cannot. Would that be agreeable for now?
Yes, Mr. Chair.
Thank you very much. That matter is settled in for now. Mr. Perkins, you have the floor, please.
Thank you. I'd like to, and the clerk can circulate this if she wishes.
Why don't we hear the motion first so I can ensure it's
That with regard to the committee's ongoing study of SDTC, and given that, one, the Deputy Secretary to Cabinet of Privy Council, Donalyn McClimont, stated that the selection processes or application-based positions are advertised through notices of opportunity on the Privy Council website. And as I have said from the outset, we would post a notice of opportunity on our website. We would invite people to apply. We would assess those applications. And given 2, former Minister Navdeep Bains said that the process is an open and fair and transparent process that publicly available to all individuals. Anyone who wants to apply can do so. It's open to anyone. And given 3, Annette Verschuren, former chair of SDTC, stated I never applied for the position of the chair of SDTC and that there were indications that I was requested. The committee therefore expressed its deep concern with the contradictions between Ms. Verschuren's testimony and the former Minister Navdeep Bains and PCO appointments, and therefore agree to A, order the production of PCO's letter of advice to Minister Bains for the Governor and Council appointment of Annette Verschuren, Guy Ouimet, and Steve Kukucha in both official languages without redactions within 14 days following the adoption of this motion. B, order the production of a copy of Annette Verschuren, Guy Ouimet, and Stephen Kukucha's application to Privy Council office to serve on the board of SDTC, if it exists, in both official languages without redactions within 14 days following the adoption of this motion. C, order the production of any briefing notes, letters, memorandums provided to Minister Bains, former Deputy Minister John Newbley, or Hilary Leftick, former from PCO, that were prepared as part of Ms. Verschuren's candidacy as chair in both official languages without redactions within 21 days following the adoption of this motion. And D, hold 2 meetings on SDTC within 14 days following the adoption of this motion and invite former Minister Navdeep Bains, Don Allen McClintmalt, and Hilary Leftick to provide clarity on the contradictory testimony.
Just 1 second, Mr. Perkins. I'm just going to suspend just for a second, consult with the clerk, and get the motion distributed.
Holy crap. So yeah, we'll be live again on the other link in like 40 minutes, 45 minutes. Let me get that link out for you guys. We'll be doing question period. So that's where I'll be live again in 45 minutes right after this committee. It's not done yet, but pretty much the committee's wrapping up now. They're just going to do committee business and vote on motions for going forward for committee business, like, you know, what kind of next witnesses we want to hear from. I thought MP Cooper's testimony to this committee was like stellar, like on point. I really would have liked to see Larry Brock in here. Larry Brock would have been all over this guy, just hammering him, because both of these guys have so many holes in their story. First of all, they were telling us about how many master's degrees they have, how they've been serving on different boards of businesses for over 25 years. But then when they come to get asked about have they even read the Act for the Sustainable Development Technology, the Act that sets place the SDTC, he goes, no, I've never really read it. He's a former lawyer who seems to not understand what a conflict of interest is. Very strange. Not really sure how. I'm not really sure how you're a former lawyer but don't know what conflict of interest is. It's a very simple law to understand. Thanks everyone for tuning in. We still got a few. There's only like 15 minutes left, so if you want to stick around, you're welcome to. But pretty much they're not going to be doing too. That was like the gist of the committee.
Floor, and then I'll turn to a speaking list. Thank you.
Thank you, Mr. Chair. During her appearance last week at the Industry Committee, I asked the former chair, Annette Verschuren, when and who called her to be on this board, and she said, I don't know exactly the date. It was a couple of times, I think, he spoke to me, he being the Minister Bains, about this, as did his policy advisor. And then I said, they called you to see if you would do this. And she said, yes. Then I asked her, and I said, in the interview, they said that the government approached you. Is that correct? And she said, that's correct. And I asked her, had you applied before you spoke with Minister Bains or after? And Ms. Vacharian said, I never applied for the position of chair of SDTC. I never applied. And then she subsequently went on another question of mine to say, I've never applied for anything in my life. A very egotistical statement. And then,
Thank you, Savage.
in response, further on, she again, when I asked her again, she said, Mr. Chair, I believe the situation was that there were indications that I was requested to consider to be an applicant for this. So she never applied. Yet Minister Baines, when he was before committee, said he got a list from PCO that only had people that applied. And the PCO said that PCO appointments, head of PCO appointments, which works for the Prime Minister, said they only provided names of people who had applied. Spontaneously, several days after the fact, Ms. Vacharian's changed her mind again, but I believe the testimony she gave before committee when she said 3 times she never applied, and that this government asked her to do this as they were pushing the former chair, Jim Bosili, out the door because he had criticized the government in the Ethics Committee for their lack of attention to privacy breaches and the surveillance economy, and a particular breach by Facebook, which in previous testimony the minister made clear on several occasions to former President Leah Lawrence of the Green Slush Fund that was irritating the Prime Minister and the government, and could you not get him to be quiet? So we've got all this contradictory testimony that's here, and as such, these individuals need to come back and clarify just exactly how did all this happen. And the reason is because in the history of SDTC, there has only been, and it's more than 20-year history, there's only been one chair that when appointed and during her appointment was conflicted, where Minister Baines told her, and where ADM Noseworthy, who sat in the meetings from ISED, said, we will manage the conflicts. And we've had testimony here today from Mr. Emet and testimony from the previous, the former president that said once Ms. Vacharian was appointed, Mr. Emet came to them and said, I'm going to go on this board of this company. I wasn't allowed to go on before because it was a conflict, but now conflicts are okay. I'll go on the board, and that company continued to get more money from SDTC while Mr. Emet was on the board. And the 82% of all transactions that happened in that audit where directors were voting conflict of interest money to boards, they had a total, by the way, of $330 million for that, according to the Auditor General. No wonder Mr. Kukucha and Mr. Emet won't acknowledge the Auditor General's report, because they don't like what she found, which was the truth, that $330 million was voted to companies that board members had interest in. So this contradictory stuff needs to be addressed. I know, Mr. Chair, that on the original motion on the study, these individuals, former Minister Baines, who's now in charge of the highest cell phone prices in the world at Rogers, and the other PCO officials, as well as PMO officials, need to be in this room, in this meeting, to be held accountable for these contradictions and whether or not they overrode the appointments process to put a political appointee in place in this manner.
Thank you. Before I turn to Mr. Desjardins and others, you look. I'll add. I will just for our witnesses, if you gentlemen could just hold fast for a few minutes. I'm just going to see if this is going to take a little while, or if it's going to be wrapped up relatively quickly. If it's done quickly, we will come back to you. So if you can just sit tight for a few minutes as we just hear some of the comments from the members. I do have to deal with the motion right off the bat because it is a matter of hand motion. It is line. So on that note, Mr. Desjardins, you have the floor, please.
Thank you very much, Mr. Chair, and thank you to the member, Mr. Perkins, for this important motion. I of course, support this motion. It's important that we ask and exhaust as much of the questions relevant to this very important audit. But, Mr. Chair, I do have a point of recommendation, perhaps, to Mr. Perkins or to the mover of the motion. Today we heard an incredible testimony from two witnesses that largely failed to accept the Auditor General's report, it would be incumbent upon me to suggest that the Auditor General be allowed to reply to what I think is instances of an attempt to dissuade the public or attempts to discredit the Auditor General and her work by overly stating its broadness or non-application of evidence. And so I'm not sure if it's within this motion that we can include the attendance of the Auditor General to clarify statements made by witnesses that have largely obfuscated, I think, the public record on the importance of her findings. And so, Mr. Chair, would it be okay for
Mr. Desjardins
Perkins to amend this to include the Auditor General?
So that is not necessary. The Auditor General has already been included in a previous motion, and it is our custom.
She's a witness that's coming forward
she'll
later?
have an opportunity.
Okay, perfect.
As well, the Auditor General has an open invitation to attend any of these hearings on studies that she has conducted, her and her office. But
I suppose that's our chair, Mr.
They generally choose to do so when it's institutions that have been put under the microscope of her office. So the OAG will attend at some point as part of these hearings, Mr. Desjardins. So I think your amendment, while has some support anyway, is moot and does not need to be considered at this time.
What is a question to our chair then? Is it possible to, within the same 2-week period to which we would be summoning this information and these documents and these witnesses, that in that same period of scheduling we can see that the Auditor General be present or at least invited as a relation to our former witness list that she's included on?
I can't guarantee that because I negotiate with her office about times that are suitable, but I can assure you the Auditor General, the OAG will be appearing, and I'm working on the calendar to ensure that the motions that this committee have passed are duly respected.
Right,
I hear what you're saying, and I'll have discussions with you. I'm now going to turn to Mr. Drouin, who requested the floor.
Just a quick question. I know there was a motion adopted on September 5th, and I'm wondering whether or not the September 5th motion would correspond to what is being asked here in the spirit of redundancy. And I do salute my honourable colleagues' willingness to get to the bottom of this, although I'm assuming that tomorrow they will vote no on the non-confidence, as they do want to see those documents, right? I'm assuming you're not going to want to go into an election this time around. And so then that brings me to why do this if you're wanting to go into an election right away? I question their motivations, if you can permit me, Mr. Chair, but I would ask the clerk whether or not the September 5th motion that was adopted on September 5th, we have reasons to believe that it would answer a lot of the motion, the items of the motion that is being asked here.
I'm going to ask you to put the questions through to the chair. Maybe make some arguments, Mr. Duran. I'm not sure. I mean, we assessed one motion. I mean, we assessed the motions. I'm not sure if you're looking.
I'm looking for nonpartisan advice, Mr. Chair. With all due respect, I respect your opinion, but I would like a consult through you, Mr. Chair. The clerk,
you're certainly new, so I will turn things over to the clerk so I can pretty much guess what she is going to say, things about being masters of their own domain. But clerk, you have the floor.
Thank you. Just for the committee, I will read the motion that was adopted on September 5th as amended, which is that the committee order the production of the following documents: the advice letter to the then Minister of Innovation, Science and Industry regarding the 2019 appointment of the Sustainable Development Technology Canada Chair, as referenced by the witness today; the minutes of all meetings of the selection committee that considered that appointment, and all communications between Privy Council Office and then Minister Baines' office, the Prime Minister's office, and the Department of Industry respecting the appointment of Ms. Verushin as Chair of Sustainable Development Technology Canada, and that these documents be deposited with the clerk of the committee within 3 weeks of the adoption of this motion. there could be some overlap here, but it is at the members' discretion to discuss this and come to a decision.
So you're welcome, Mr. Knight. The floor is yours, of course. You're welcome to make any amendments to the motion you see fit, if you think that is in order.
Well, I'm just wondering if there's you know, I'm always here to work with others as well. I'm just wondering if we can park this and wait till we get the information, and if it's not satisfactory to Mr. Perkins, then Mr. Perkins could reintroduce his motion and we can move forward on the adoption of that particular motion. But if it's to be submitted to this committee by 3 weeks, we're getting close to the end time, so I'm assuming that documents will be showing up at this committee fairly shortly.
Thank you. Madame Séclé-Desgagnés.
De notre côté.
On our end, we also support the motion. I think that the contradictions that we see among the testimony are very problematic. And the contradiction that was noted in the motion which we are debating today at study, there are others, notably on who managed Sustainable Development Canada, because on the one hand there is the ADM of Innovation, who said it was the Canada Research Council, and then we had a director from NRC that said they weren't the ones. There are many contradictions in the testimony which are not allowing us to do our work as parliamentarians. So we hope that we'll move to a vote on this very quickly.
Very much. Clerk, call the question, please. I'm afraid the question's been called, Ms. Khalid.
But Chair, I had my hand up before you called the question.
I did not see your hand, Ms. Khalid, and I waited.
Oh no, Ms. Khalid's actually in the committee?
Call the question. Question's been called.
Sorry, Mr. Chair. We're talking about 5 seconds. She said she wanted to speak.
Mr. Duray,
I'm assuming I've been on other committees with an opposition chair. I've been sat on government operations for 6 years. There's always this collegiality back and forth, of course.
Yes.
Ms. Khalid says she wanted to have the floor, but you gave her no time. I'm just wondering, how are we running the show here?
Mr. Duray, I appreciate your enthusiasm. I scan the room as members
Chair,
are talking.
I swear to you, I had my hand up while Mr. Duran was speaking.
Ms. Khalid, you know my practice. I was even deliberately slow between the end of Madame St. Clair and before calling the.
I thought you recognized me and put it on your list, Chair.
And call the question Chair. Has been the question. The question
Chair,
has been called.
No, Chair.
Ms. Khalid, I was going to say that is your option, is to challenge me on that. So, the chair has been challenged. Clerk, please.
Great.
Shall the decision of the chair be maintained? Ms. Bradford?
No.
Ms. Khalid?
No.
Monsieur Drouin?
No.
Mr. Erskine-Smith?
No.
Ms. Yip?
No.
Mr. Nader?
Yes.
Mr. Stewart?
Yes.
Mr. Perkins?
Yes.
Madame Saint-Clair-Desgagnés?
Oui.
Mr. Desjardins?
Yes.
5-5.
That's yeah.
5 yeas, 5 nays.
So now it's up to the chair.
Thank you. Please call the question on the motion as tabled by Mr. Perkins.
Shall the motion of Mr. Perkins be adopted? Ms. Bradford?
No.
Ms. Khalid? No. Mr. Drouin?
No.
Mr. Erskine-Smith?
No.
Ms. Yip? No. Mr. Nader?
Yes.
Mr. Stewart?
Yes.
Mr. Perkins?
Yes.
Madame Saint-Clair-Desgagnés?
Oui.
Mr. Desjardins?
I vote in favor, yes.
The motion is passed. I'm now going to go back to the witnesses. Ms. Yip, you have the floor for 5 minutes.
So I'd like to, thank you, Chair. I'd like to turn back to the Ethics Commissioners. We may report. In July 2024, the Ethics Commissioner dismissed allegations that you had contravened the Conflict of Interest Act, given the board's decision to approve COVID-19 payments to companies, which include Lithium Recycling Inc., which you held shares in. What percentage stake did you hold in Lithium?
1%.
Sorry. Thanks. Just apologies to the translator. I've now taken off my earpiece. So the Commissioner's decision states your interest in Lithium was insignificant and that it did not pose a risk of conflict of interest. Can you explain the Commissioner's decision as you understand it?
Le commissaire a appliqué le...
The Commissioner applied the principle of ad minimis because my participation was minimal, and he deemed that it could not influence any decision taken by me.
Can you explain to this committee how the board approved the one-off COVID-19 payments to the companies in the portfolio in the last month of the fiscal year of 2020 and 2021?
Merci, Monsieur le Président.
Thank you, Mr. Chair. As I mentioned several times, the situation was difficult for businesses, federal government, and provincial government assistance was not yet made available. It came later. And the board discussed it and decided to propose a project that to give assistance to businesses in difficulty. And we talked about 14 months and an average of that did not justify the additional assistance, but the risk capital people will tell you that businesses have a runway of 18 months, and we had businesses that had reached 14 months and they were in difficulty. Each of the businesses had been consulted by management, could confirm that it was not a business that couldn't, they were justified by issuing sums, and that's how the program was approved en masse without any one company. It was a COVID program that was approved by government representatives before it was carried out. The issue of conflict of interest was raised a number of times, and the issue of interpretation and legal opinion on the Conflict of Interest Act, but I think that we all understood, furthermore, that there was no misappropriation of funds.
The blower testimony states that every company associated with the board members, including the chair, benefited from grants they approved. Can you speak to this, given you were there?
The
businesses where legal opinion said, given the universal nature of the measure, or where no company was singled out, and that the conflicts had already been declared previously, they did not need to move forward. The alternative would have been to have multiple votes, which would have been contrary to the intention of the program.
Before joining the board of SDTC, you had previously worked as an advisor to SDTC from 2006 to 14. Is that correct?
Is correct. Wait.
Yes, that's right.
So
crap,
that
the
was
interpreter's so
during
loud.
The Harper government. What was SDTC's mandate throughout the Harper years? What type of work was it funding?
Le mandat de...
The mandate of SDTC was essentially the same. It was funding businesses for projects, startup projects on greenhouse gas emissions. In my case, I helped SDTC at that time to establish an investment fund of $500 million, the Next Gen Biofuels Fund, which was an initiative by the Harper government to meet American competition with similar programs at the time, and I was an external advisor on that. Thank you very much.
Fourth and final round, I'm going to truncate it slightly. Government opposition members will have, official opposition members will have 4 minutes, and the third party will have 2 minutes for this last round. Mr. Perkins, you have the floor then for 4 minutes, please.
I like that.
Thank you.
Give the Conservatives extra time.
I'd like to go back to this Auditor General report. Maybe I could start with Mr. Kukucha, so and then Mr. Met. But Mr. Kukucha, there were board members that had more conflicts of interest than others, and one of them was Andre Lise-Matot, who is named the most in the Auditor General's list of that. When I look down the list of companies that her company, Cycle Capital, is invested in, it looks hard to me to see that she could ever be in a board meeting, that she was recusing herself all the time. Did you see her leaving the room a lot?
Honourable member, I joined the board at a time, but I believe it was Ms. Mathot's last meeting. So I was not privy to any of the previous work or conflicts she declared.
Mr. Ouimet?
Yes, I participated in the council with Ms. Mathod. She was there before I was, and she left before the end of my mandate during a time when I observed her behaviors. Every time a conflict was declared, she recused herself from the virtual meeting room.
Encurum Alberta Inc., MindSense, Spark Microsystems, Concentric Agriculture, Polyservant, ViewReal, Cellfuel, Green Mantra Technology, Crystal Labs, Borealis Wind, Development Efficient, Equisphere, Global Spatial Technology Solutions, Fractional Systems, GHG Satellite Inc., Helen Inc., Horatio Inc., Metamaterial Technologies, Peak Power, Pure Solid Treatment Solutions, Terramera, Advanced Intelligence Systems, Anomera Inc., Cell Fuel Inc., I guess, and Crystallis and Fractional Systems. Total $114 million, Mr. Emet, while she was on the board that the financial interests of her venture capital firm had interest in all this. Awful lot of transactions that she left the room for. She probably wasn't in the room very much then, is that right? She was out of the room by the looks of all of these all the time. That's $114 million. Do you think it's appropriate that a board member had $114 million invested in companies she had a financial interest in during her time on the board?
Monsieur le Président, je n'ai jamais...
Mr. Chair, I wasn't closely following her interests. All I can say is that I observed her behavior, and my memory is that she declared a conflict of interest and recused. I won't weigh in further on that.
You weren't following her interests. Pretty hard not to when they brief you at the beginning of every meeting of the conflicts that each director has, and then go about voting for those projects that director has when she has them. And Mr. Kukucha, you referenced that she left the board when you did. Are you aware that she left the board and went to Canada's Infrastructure Bank as a board member?
Honourable member, I did not track Ms. Mathot's activities post-SDTC in the one board meeting I sat in with her.
You're not aware of her testimony here that she got $170 million from the Infrastructure Bank board while Ms. Mathot went over there?
Honourable member, I was not.
issue just one last thing, Mr. Kukucher. You hadn't read the Act when you got on the board. When I joined the BDC board, I read the BDC Act. It's not a difficult thing. You should always do that when you join a board. Secondly, the contribution agreements, you don't seem to know what they were. They are not the agreements between SDTC and the company being invested.
Your question,
They
Mr.
are,
Perkins.
I said, directed limits on what you can spend on. Did you read the ISED directed contribution agreements before you participated with everyone else in voting money outside of those terms to companies?
Honourable Member, there's two types of contribution agreements. The contribution agreements that are made between the companies and the organization when funding is granted, and those were the agreements I was referring to. And yes, I take your point. There is an agreement between the government and the broader organization with regard to funding flowing. That document was not made available to me as part of my onboarding package, so I did not have an opportunity to read that.
Thank you very much. Mr. Durain, back to you. The floor for 4 minutes, please.
Thank you, Mr. Chair. Was Mr. Perkins appointed by Conservative government on the BDC? Just checking. Monsieur Ouimet, pour les informations.
Mr. Ouimet, you said to my colleague that you had 1% of shares in that company. Is that correct? What did the Ethics Commissioner say about that? Did he say that it is a significant share for decision-making at Edition, or did you simply say that you didn't have a significant enough interest in it? The Ethics Commissioner said that it was under the de minimis rule, so it was considered insufficiently large in scope to influence my decisions, and so he rejected the allegations against me. With 1% of interest, are you called to weigh in on management decisions or on grants that the company seeks out, or you just have 1% and you 1% is a shareholder position, but as was said, I'm a member of the board of directors, so I participate in decisions, but I did not participate in decisions at SDTC at Lithion, and then there was a change in the board, and there was a change to the contract, and I recused myself when there was a change to the contract, and I left the room. And then there was the COVID payment portion where I did not leave the room for the reasons that we know, for legal reasons, which were examined by the Ethics Commissioner, who concluded that there was no breach of the Conflict of Interest Act. On the COVID payments, when there were allegations saying that 14 months after the fact there was no link to COVID, even though the pandemic lasted more than 2 years, what impact can that have on a company even 14 months later? How difficult is it to predict either sales or the needs? What is the current environment right now? Allow me, Mr. Chair, to specify that it wasn't a payment 14 months later. I believe that the comment by the honourable member earlier said 14 months of runway. So when we look at a business and risk capital, it's not generating revenue, and it has expenditures that it is accruing. They're in survival mode, so the average of survival of the companies was based on the 14-month comment. I didn't verify that. That's what was said. Other things were taken into account because all businesses had difficulties fulfilling their projects. Sometimes the project was canceled with partners. The costs of companies increased rapidly, uncertainty as well, and the financial balance sheet, and that was what the board of directors observed, and they created this 5% contract that resulted in 2 payments. Thank you very much. I think I have 3 seconds left. Thank you very much, Mr. Ouimet. Thank you very much. Next, Madame Sinclair Desgagnés. Mr. Ouimet, can you please briefly describe the financial health of Lithium before the COVID pandemic, but also during the COVID pandemic? Mr. Chair, is it relevant to discuss the financial state of a private company? It is not a public company. Mr. Chair, can we suspend or? Mr. Chair, you didn't hear what happened? Okay, because I lost a lot of time there. Yes, okay, well, I was asking Mr. Ouimet to describe the financial health of a company that received public funds. Mr. Ouimet asked if it was relevant, and I think it's up to you to say yes. Yes, please. Very well. Lithium was a startup, and it didn't have significant revenue, and it needed to make considerable investments before becoming successful. We're talking about an integrated technology for recycling lithium batteries. So we're a 2-phase of investments. They've already built a factory, and the next project will be a billion-dollar project. So the financial health of a business, it needs to be assessed periodically, and there need to be periodic investments to achieve a healthy state. And that is how SDTC funded it. So my question was on just that. Do you think that Lithium with $400,000 was absolutely necessary for the financial health? Was it so fragile at the moment that it in the 2 periods that it received money in March 2020 and in March 2021 that it needed to receive nearly $400,000 in total? Mr. Chair, the board of directors of SDTC proceeded with these COVID payments and did not assess the companies individually. And as a member of the board, we did not see the financial balance sheet of each company. It was a program-based approach. Do you think that it was a good decision to proceed this way and to not look at the financial health of each business one by one? I'd like to specify that the board did not look at the financial situation of the companies one by one, but the management of SDTC had an allocation from the board and then contacted and verified the financial situation of each of the companies before proceeding to payments at management's discretion.
Thank you very much, Mr. Chair, and thank you again to the witnesses for being present. I've asked every witness this question related to this audit as it's been relevant to the Public Accounts Committee, and that's been on the issue of recovery of funds. Taxpayers are hardworking people. They show up to work every single day. They show up without any bonuses or extra paychecks, and they pay their taxes, and they do it really well, and they're trying their best, especially right now when things are extremely expensive. I've asked this question mainly because I find that there's oftentimes a misjudgment or misvaluing of taxpayers and how much they actually work and contribute to our society. There was a recommendation made by the Auditor General that asks that Sustainable Development Technology Canada should reassess its projects approved during the audit period to ensure that they meet the goal and objectives of Sustainable Development Technology Fund and all of its eligibility criteria. It's incumbent upon members of Parliament to ask the very difficult question of recovery of funds. I believe sternly that projects that were deemed ineligible should be recovered and ensure that the taxpayers get justice in relation to those funds that were dispersed and approved of by a board that allowed for funds under a very direct conflict of the legislation that enables them to get that money back. I agree with the part of the Auditor General that we should reassess this, but I go further and suggest that we need to recover some of these funds. Of course, the victims of this mismanagement with SDTC is taxpayers. It's Canadians, it's small and medium-sized businesses, and it's also our environment. It's deeply troubling that this was allowed to continue for so long, particularly under Ms. Vercherian's chairmanship. It was devastating to the small and medium-sized businesses that are doing everything they can possibly do to create innovation, Canadian innovation, towards what is a very serious issue plaguing our society. So my question, simply put, do you agree that we should go not just reassess the projects that were approved during the audit period that were deemed ineligible, but we should also begin a process of recovery for those funds? Mr. Kucha.
Mr. Kook, how about that?
As I'm honorable members, I'm no longer a member of the board. I will leave that to the new board to decide. I made my statement in my opening statement that I think a lot of good work was done by this organization and a lot of deserving companies receive funds. And I acknowledge your statement, obviously. I have nothing further at this time.
Et voilà, Mr. Ouimet, avez-vous une réponse, s'il vous plaît?
Mr. Ouimet, do you have an additional response?
Just call a spade, dude.
The observations of the Auditor General are recognized in terms of non-compliance. And I already indicated in my opening statement that all of the investments at SDTC made by the board at the time that I was there were based on development plans and investment frameworks approved annually by the board, the department, and the minister responsible for the file. Where there are issues that the Auditor General recognized was that the legal framework was not updated quickly enough by the government to take into account the operational needs approved by SDTC. So it is an administrative issue. And for example, if you look at an ecosystem, why do you have ecosystem? It was noted that in some provinces, BC, Ontario, Quebec, there were a lot of applications, and in some provinces the ecosystem was so weak there was nothing, and the provinces did not receive their fair share. So let's create an ecosystem that will encourage this. Thank you. Thank you very much.
Mr. Perkins, you have the floor. Pardon me. Two more members to hear from. Pardon me, Mr. Perkins, you have the floor, and then it's Ms. Khalid will end us out of this. Mr. Perkins, please.
Thank you, Mr. Chair. Mr. Kakucha, I want to go back to how I ended my last session because something you said sort of astounded me. So just for folks watching, anyone that's following, because this is a complicated issue, the Green Slush Fund and this. Parliament appropriates money to be spent and transferred to the foundation, as it's called, in the green technology space. Over the years, it's been about $22 billion, but the last batch was about $750 million. And the fence posts, the guideposts for the foundation board in spending that are called contribution agreements between the industry department, and says you can spend Parliament's money on this and only this. And the Auditor General found that in many instances, the board had gone outside of that, particularly the COVID payments, but other instances. A total of about $58 million was spent in the 5 years she looked at that were outside of the contribution agreements. In other words, against the rules that Parliament approved the money for. So you mentioned, Mr. Kakucha, that in the orientation package, when you became a director, they did not give you the contribution agreements to review, so you understood those guideposts. Is that correct?
Mr. Chair, to the best of my recollection, they did not provide that, and I defer to Mr. Ouimet's testimony where this was legislation that had not been updated, and we essentially were working in a system where it was my understanding that was provided both verbal confirmation by the CEO and from the ADM present that we were working within the government's approval.
So the question then is, and you were both on the investment committee, so how do you make these decisions without knowing the parameters? I mean, you said that The ADM was there. So the Auditor General referred to the fact that the Assistant Deputy Minister, a senior bureaucrat in the Industry Department, sat in every board meeting, every single board meeting. And we're to believe that the minister didn't know what was going on when he had an official there. You're saying, and in the Auditor General's report, it says that the official, the board interpreted the official not objecting as agreement that what the board was doing was correct. Did you feel that way?
Honourable member, we on the investment committee, we were aware of the general parameters of why we would be making investments around. There were environmental targets, there was GHG reductions, there was circular economy. There's a whole lot of criteria that we judged projects by and that the expert reviewers reviewed by. So when projects came to the project review committee, we very much had a set of criteria which we reviewed them against and worked very hard to do so.
You don't know that those criteria, whether they were actually consistent with the ISED, the Industry Department's contribution agreement, since you never saw them.
As stated, I don't recall receiving a copy of that in my orientation material, but that was a very long time ago, and a lot has happened since then.
Well,
obviously,
Mr. Emet was appointed long before you. So, Mr. Emet, did you have access to the contribution agreements at any time from your orientation on the board?
Absolument.
Yes. I read the contribution agreements, and I was perfectly aware of them. And I saw how the investment plans evolved. Just to give you a quick example.
You saw them.
Yes, I was aware of them.
Still approved money outside the contribution agreement then, since you were aware of them.
Non, j'ai approuvé des investissements en conformité.
No, I approved investments in accordance with the government's investment guidelines. And sorry.
Time is up. Ms. Khalid, you have the floor, please, for 4 minutes.
Thanks, Savage. Oh, double Savage. Holy crap, man. You're killing it today, dude. Oh, no, not Miss
There is no way in
Khalid.
which I condone the misappropriation or misuse of public funds at all, whether it is through SDTC or any other way. So I just want to give a little bit of a history before I ask you my questions. Since its creation in 2001, SDTC has invested more than $1.71 billion in over 500 companies that have generated $3.1 billion in annual revenues, created 25,400 jobs, the commercialization of 224 new technologies, and reduced greenhouse gas emissions by 25 megatons of carbon dioxide annually. Do you think that the conduct that has occurred here has inhibited or somewhat taken away from the credibility of this program? And I'll ask Mr. Kukucha first, and then I'll go to Mr. Ouimet.
I think I can only speak for myself, and that I acted in good faith, and we were working under guidelines and an understanding that we were making best efforts to help contribute to the clean tech companies helping drive the economy in Canada. It would be a shame if that was brought into question based on what's occurring here. And having said that, we accept the findings of the reports and turn the matter over to the new board and government to continue funding as they see fit.
Thank you. Monsieur Ouimet?
Oui, comme je l'ai dit.
As I said, we recognize the findings of the report that was tabled. I think that all the recommendations should be implemented. The results achieved by SDTC are very convincing, and that they contribute to the Canadian economy. Obviously, the period the current period is a difficult one for the organization and for businesses, but we hope that better days are coming. No reports proved misappropriation or wrongdoing. That sums were misappropriated. So let's take note of that as well.
Merci, monsieur.
Thank you, sir.
My understanding is that there is a new process. There is a transition to the NRC with all of this. Now, talking about misuse of public funds, Mr. Kukucha, did you previously appear at the industry committee earlier on this exact issue?
Honourable member, yes, I did.
And were you asked any different questions today than you were asked at that time?
Madam Honourable Member, we've been asked a lot of questions. The tonality of this meeting was obviously fundamentally different than the last one, but I can't be specific.
Wanda, welcome in.
Yes, I've probably been asked several questions. It's been a very long and challenging meeting, Honourable Member.
So how do you feel then, Mr. Kukucha, when there has been a very clear and very quick direction by the Minister on having understood the wrongdoing and having rectified it, created a path forward for it? How do you think that these kind of questions to you help or hurt our democratic institutions and the trust within which? And we've clearly outlined today how SDTC has really helped the clean tech sector.
Honourable Member, facts matter and context matter, and that leads to truth and ultimately to trust. And our democracy and our institutions will be hurt if we don't follow those processes. So I've tried my best in this hearing to provide context and the facts I was aware of, and I've tried my best to do a good job as a board member to enable the sector and do a good job. And I believe I've done that in good faith and having acknowledged some of the errors along the way.
Thank you very much. That is the time. I want to thank our witnesses, Mr. Ouimet and Mr. Kukucha, for your testimony in participation in relation to the study of Report 6, Sustainable Development Technology Canada.
Okay.
Vous pouvez soumettre.
Okay, so that's it for this committee. We're going to head right over to the other stream. I've already linked it a few times. We're going to go watch question period, and we're just going to go straight to the other stream, guys. No stopping. I will see you guys on the other stream. And thank you, everybody, for tuning in. Thank you, everyone, for the super chats. I know we got Wanda just joined into the club. Really appreciate that. Savage, as always, man. No more super chats in the next stream, Savage. I'm watching you. No worry. You've been crazy today, so thank you so much for that, man. But yeah, guys, let's go watch question period. I put the link in the chat.